All right. We need Mr. Hall. We're ready for Mr. Hall. I don't know if you've got a second person with you.
Yeah, I changed because I don't know. I put not like the time. It's not like I have to it's not some days time. But anyway.
All right, let's go on the record in State versus Hall. It is Wednesday, a little bit before 1. We need to do the charge conference. Mr. Hall is here in court with his lawyers. Not wearing a tie today. Is that by choice? It's fine with me. I just want to make sure you had enough time to get dressed. You're good. Okay. We've got 2 of our prosecutors here, Investigator Rickman, so we're ready to go. I shared with the lawyers last night a draft jury charge. This morning, Mr. Hiles forwarded 2 more requests or something that I may have omitted. I don't know if either you forgot to request it or we left it out, doesn't matter. You're requesting that I include excessive force as well, the pattern for that, as well as revenge. Both those seem to fit. I'll tweak the language a little bit, but I think both of those are appropriately included. Ms. Feely, any objection to including excessive force and revenge? Okay, what about excessive force?
We are fine with excessive force. We object to the revenge instruction.
Okay.
We believe it inserts subjective intent into the objective determination whether the amount of force used was objectively reasonable. And I don't think this has, I think it's unnecessary as well. I think the other jury charges cover essentially, other than that part, the judge, what is going to be instructed to them.
Okay. Mr. Hiles, any response to the concern about subjective intent, objective intent, this being cumulative?
Which charge did you object to?
Revenge. She does, Ms. Feely does not object to excessive force. That's in. There's no objection. I think it's appropriate. Revenge. She voiced the concerns that I just summarized.
So no, I think it's up to the jury to determine what intent is, and intent as to why he committed these acts is whether it is revenge or it is actually self-defense. I don't think it makes anything subjective. It is your instruction that it is an objective view, as well as the evidence that we heard yesterday is, I think at least 6 times he said, check me. He referred on 3 separate occasions of being dressed down by a little bitty boy when he was a grown-ass man. So I think that makes it absolutely relevant to this case and appropriate charge.
Okay. I'm going to include it over objection. I'll need to tweak it a little bit because there's some parentheticals in there. And of course, I'll share the proposed final version for people to offer any additional comments. And we'll go through what I shared with you yesterday. I just wanted to capture the latest requests, excessive force and revenge, both in revenge over objection. And then Ms. Feely responded saying that the defense would like defensive habitation included as well. And she gave the pattern charge number. Ms. Niles has sent me that language. Any objection? The pattern actually has several different scenarios. I'll only give one of them, but any objection, Mr. Hiles, to a pattern, to a charge for the jury on the concept of defensive habitation. Defensive self is already in there, and this is another form of justification. Mr. Rao?
I think there is some slight evidence by virtue of Stephanie's testimony indicating that he didn't live there. I think there was some contradiction in the statement that she provided to Ms. Berry as it relates to that. I think understanding that that's for the jury to determine the conflict. We won't object on that basis.
Okay, I agree that there is evidence. It doesn't take much. It's any evidence in the record to support a charge. I will include a version of defense of habitation. Give me 1 second. Okay, if you look on the screen, we've got the draft charge minus the new additions. I'm going to scroll to areas where I've got questions. If I skip over something you wanted to discuss, tell me to go back. My first area on page 5, defendant's choice not to testify. I will certainly include that if Mr. Hall in the end chooses not to testify. If he decides to testify, then I will not charge the jury on that. I don't think there is any evidence about which I have instructed or will be instructing the jury that they can use it only for a limited purpose. So I think that should be removed. I don't know who requested that. You don't have an objection to removing it, Ms. Feely. Mr. Hiles? It's out. Identification, perfectly valid charge. This case, I don't think requires a charge on identification. It's a question of why, not who. And so my suggestion is that we not include identification. Ms. Feely?
Well, according to the jury's questions yesterday about being interested in the fingerprint of the firearm, I think there might be a slight issue, so we'd ask the court to give it.
Okay. What I will do then is real time. Give the part that is not struck out. So what I'll give is identity is a question of fact for you to determine. In fact, I don't say that is a question for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. I don't believe we need to bog the jury down with the 6 factors that generally relate to stranger on stranger identification. That's not this case. But your point's well taken, Ms. Feely, based on a juror question. I don't think there's any evidence to support it, but well, there's enough because they had that question. So I'm going to give this distilled version. Are you all right with that? All right. Any objection to that, Mr. Hiles? All right. Done. And I'll remove the other part. Then we get to knowledge. I don't know who asked for knowledge. I don't think that fits in this case. This isn't the I didn't know what the white powder was kind of case, or I thought that this was my friend's house. It wasn't a burglary. I entered with permission. Did you ask for knowledge, Ms. Feely? Okay. Any objection to knowledge coming out, Mr. Hiles? Okay. premeditation is already, I didn't know there was a specific charge on premeditation, because in the pattern for malice murder, there is a line about malice being formed in a moment, and that there's no specific length of time. So I'm not inclined to give premeditation, but I'm open to an argument. I'm assuming it's not from you, Ms. Feely. All right, Mr. Hiles?
No.
Okay, it's out.
I think it's when the jury has a question.
I can define that term. Got it. I'll have that in my hip pocket. I am charging on voluntary, but not on either of the involuntaries. I don't think there's a set of facts that support either of those. Ms. Feely, I'll hear you on that. I don't know who asked for all of them, and it may be that someone just said, give the lesser included, and Ms. Niles put them all in.
I would ask for both of these specifically. We would be asking for involuntary manslaughter, number one, I guess, by either the defense of reckless conduct or putting assault.
What's the reckless the reckless conduct is firing 8 times through a door?
It's a lesser.
Okay. All right. What about the lawful act? What was the lawful act that occurred? Okay, but you get self-defense. All right. Even though I've been reversed once for not including lawful act in an unlawful manner, I don't think that's this case. It's not it was an accidental shooting. That was the context of the case where it was apparently plain that I should give the lawful act in an unlawful manner, even though Supreme Court precedent said don't. But here, it's not an accident case. It was an intentional pulling of the trigger. It was either justified, or it was reckless, or it was murder, or it was voluntary. But if you want to make a record as to what the lawful act in an unlawful manner, because of course, self-defense is lawful, but if it becomes unlawful, i.e. it's not justified, it's not involuntary, it's either voluntary or murder.
Yes. Yeah, it started out as lawful and maybe it makes it unlawful.
Yep, or it makes it excessive force and then it's not justified, like shots 2 through 8. Okay. Pardon?
So we're just.
Okay. Mr. Hiles, your thoughts about felony involuntary, unlawful act involuntary, premised on reckless conduct?
Yeah, I don't think there's any evidence that this was what reckless conduct. It was either, I think the analysis is it was either justified or not. This was an intentional act. There was no reckless when you act kind of in disregard for life.
But what about the fact that it was a closed door? So it was reckless to fire wantonly through a closed door, not knowing for sure. In other words, I shot just to scare. You keep leaving, don't come back. And so I'm going to fire a few 8 through the door. I didn't know he was there. I figured he'd gone down the stairs. I waited for a little bit after the door closed. And so it was reckless to shoot through the door. I shouldn't have done it, but I didn't intend to hit anyone. I don't know how persuasive that is, but I don't, the evidence would support that argument.
I think the evidence supports that it was an aggravated assault that was intentional. And it was reported or repeatedly said over and over again, that he checked me and that I responded. There was not a single piece of evidence presented that showed that it was not intent to shoot somebody.
What if out of the fit of rage, he had fired once through the ceiling and it hit someone? I know there's not an apartment above, but pretend there was. It hit someone in the foot above. That would be reckless.
So he knew that the defendant was directly on the other side of the door. If he was shooting upstairs, his intent, you could say then, would be to scare somebody on the other side of the door, not knowing who was above him, but he knew exactly who was on the other side of the door.
Okay. I'm going to leave it in for now, but we haven't heard all the evidence in the case, so we may hear more. Did you want to add something on that?
I did.
Okay.
On the case that you referenced earlier, the McBurney case.
Sure.
The Supreme Court went against all precedent as it relates to the misdemeanor involuntary manslaughter. But as it relates to the felony involuntary manslaughter, the reason that was appropriate to do there because the defense there was accident. Here, the defense is not accident. Here, the defendant himself, in his own words, when he was on the phone with Detective Berry, made clear his intention was to shoot at the victim. So here, it's not an accident defense, it's a justification defense. He's saying I was justified in shooting. There's been zero evidence that he accidentally shot the victim or he accidentally shot through the door or shot at the door. So that's be the state's contention is why involuntary manslaughter, whether it be misdemeanor or felony, is not appropriate here because there's been absolutely no evidence or any record made as it pertained to what happened that night was an accident.
What is the evidence that you would point to me to or a jury to for the reckless conduct, which would be I accidentally shot. I didn't accidentally pull the trigger, although that could also be reckless conduct, as in I had it in my hand and we hit a bump and it caused, I mean, there's clearly 8 intentional trigger pulls.
So in the video that states like yesterday, Mr. Hall says to Detective Berry, I did not intend for this to happen. So, and he also, I think, contends at one point that he didn't know that he was on the other side of the first bill.
That's the first part I remember. The second part, where are you getting that? He contends at some point that he didn't know. And this would be the immunity testimony or where do you get that from other than your client told you?
The timeline makes it, if he was shoved out, there wasn't going to go down the stairs. I mean,
Okay.
Your Honor, I think the response to that though was, I didn't intend for this to happen, was referring, when he said that, he was saying, I didn't intend for that man to come in my house. It wasn't that I didn't intend to kill him.
Okay. So I'm open to case law. I'm not charging the jury quite yet, but I am understandably a little leery about not including certain lessers. I'm not doing misdemeanor involuntary because the defense isn't, I was doing something lawful that became unlawful, because then it would be, I'd be saying it wasn't justified, in which case it's voluntary or it's murder. I don't think that's what you're going to argue. So I won't give that. I'm on the fence with reckless, and I will err on the side of including rather than excluding something.
And if I could just add one thing, then it almost doesn't make sense to include the lesser included of voluntary. Because if you're asking for the lesser included of voluntary, you're saying I intended to do what I did, but there's mitigation and justification for what I did. And you can't have both, to be perfectly honest with the court, because the argument is completely, they're opposite.
Well, yes, but there are a number of precedents recent from the Supreme Court saying, I don't know why a lawyer would do this, but if there is evidence he wasn't there, then you need to charge on alibi. And if he is arguing the alternative that it was self-defense, you need to charge on justification. They are inconsistent defenses, and why a lawyer would advance that, don't know, but it's not the judge's job to say that would be dumb, and so I'm not going to charge that. So I don't disagree with you that they're inconsistent, but there are a number of precedents that say if there's evidence to support both, it's conflicting evidence, and in theory, a defendant would cling to one, it's self-defense, or it was the other guy. But if there's evidence, Ms. Feely has pointed to, there seem to be doubts about whose hands were on the gun. Maybe there's reason to think Ms. Stuckey fired the gun. So that would be, I didn't do it, but I also want to argue self-defense. I did do it. but it was justified. And I think what you're describing falls into that inconsistent defense. And there may be case law out there that says, if the evidence supports voluntary, I think it does, then you can't charge on reckless because it's a conflicting mens rea or something. But I do know that cases have been reversed because a judge said, that's ridiculous. If the two are mutually exclusive, no one would argue both. And the Supreme Court has said, not your call, judge. If a lawyer wants to do a sort of shotgun approach and say, well, my client wasn't there, but if you decide he was there, then it was justified.
Well, that makes sense to me because the lawyer saying the state has not proved beyond a reasonable doubt that the defendant was present at the scene. That situation is very different than the situation we have here, because there would be a lack there of evidence to show that the state didn't provide to show that the defendant was there. But the attorney in the cases you just described would say, if you do believe he's there, would say you believe the state puts the defendant there. Well, he was there, but he was acting in self-defense. That's not the same situation we have here. We have a situation where you're saying what he did was intentional, but he did it because he was defending himself, or you're saying what he did was not intentional and the outcome was death.
So here's my stab at being a defense attorney who wants to argue these all. Ladies and gentlemen, this was all a tragic accident. Mr. Hall fired the gun 8 times because he was trying to scare this young man who had just put a gun in his face away. He didn't know he was behind the door. It was reckless of him to shoot through the door. He's terribly upset that it happened. He didn't mean to shoot anyone. But if you think that it was a little bit different, then clearly you could see that my client was acting out of fit of passion. Someone had just burst into his place, put a gun in him, checked him, etc., and he wasn't thinking. It was a fit of passion when he intentionally fired through that door. So you're going from reckless to voluntary to hey, he was defending himself. I guess you'd start with that, is that yes, he shot. He didn't mean to hit anyone, but if he did, it was in self-defense.
There's not even slight evidence to support the first scenario that you described involved. There's not like there hasn't been a single piece of evidence during this trial that would support even slightly that argument.
So you're saying that the only evidence in the case is that Mr. Hall was certain that by firing through the door, he would hit Mr. Blunt.
No, I'm not saying that. I'm saying if he was certain, the only evidence is that he was certain in his intent in firing through the door was to prevent, I guess, serious injury or death of himself or third parties.
We'll say himself, sure.
There's been absolutely no evidence of the contrary, that he shot through the door without the intention of warding off somebody or something of that nature. There's just been no evidence of accident, and that's really what involuntary manslaughter is. I didn't intend to do what happened, and the intention is, I'm not talking about killing, but I
didn't intend the outcome. I intended to pull the trigger. It was reckless for me to shoot through the door. I should have made sure that Mr. Blunt wasn't. I should have made sure he'd gone down before I fired these warning shots to know you better not come back in. It's not inconsistent with the state asking for excessive force. The state wants excessive force, and the defense would be, well, he didn't think he was shooting at the person. The wiser move might have been to shoot through the ceiling or through the floor or something, but he fired in the direction of where the threat had been. He thought that the threat had, it's inconsistent with self-defense if then the threat had left, other than I want to make sure he doesn't come back. I'm not arguing that it's a sound approach to argue all these things, but it would be unfortunate if the jury comes back with a verdict on malice murder and failing to charge on felony involuntary was deemed to be a reversible error, because there is a fragment of evidence, a statement of I didn't intend it to go this way, that a juror could decide meant sure, he was shooting warning shots. He didn't mean to hit him. He didn't know he was behind the closed door. Because what we don't have is evidence. We don't have Ms. Stuckey saying, oh, we could both see through the door that he was standing right there. So I don't think it's much. I think it is inconsistent. I don't know that it would advance a thoughtful defense to argue in those different directions. But again, not my call to dictate the coherence of a defense presentation. So I'm going to extend my invitation again. There may well be case law saying, actually, there may be evidence of both reckless and self-defense. You don't get to argue both those, because if you're going to argue full-throated self-defense, then you did it intentionally and there were no mistakes involved. Okay?
I think we're getting a little bit mixed up on burden of proof it is too, because he's saying I can't have it away, but if the state didn't prove that he intended to, then that would be consistent. The jury could find he did it without intending to, which is why we want involuntary manslaughter.
I understand why you want it. And I don't think that right now I ought to exclude it, but I will exclude the misdemeanor involuntary.
I wanted to just make one more,
Can you turn your microphone on, please?
I also want to make sure that we're being careful about, and particularly in arguing facts that came out in the immunity hearing that have not yet come out in this trial. That may become not an issue if the state plays it. But I also just wanted to mention that I flipped through. I didn't watch every second of the immunity hearing, but the only time I saw Mr. Hall demonstrate anything, I was actually on direct, I think, and he stepped off the stand and he's out of frame anyway. So I just wanted to make sure that we weren't going to be playing the video portion if the state does intend to play.
Got it. So what we would have if the immunity hearing is replayed for the jury would be a narrative of a reenactment, but no video of the reenactment. I mean, it might be Mr. Abate saying, and then where was your hand? And Mr. Hall saying, my hand was here. But we don't know where here is. We have those words.
Right. And we wouldn't in the video either. Because,
right.
And even Miss Rivers is like, I can't hear him because he's,
okay,
not near a microphone.
Okay. Pressing on in the jury charge, on page 12, we get to justification generally. I've never understood why this is in the pattern because it's almost more of an instruction to the court. I'm certainly charging on justification, but I'm not giving that general charge. We get into justification and the use of force in defense of self, which I will supplement and also have use of force in defense of habitation. Any objection to removing the general charge?
Yeah.
Must verbalize it.
No.
No. Okay. I also am paring down the justification of use of force in defense of self because I don't think that there is evidence that Mr. Hall provoked the threat or use of force against himself. One could argue he had the argument with Ms. Stuckey, but there's no evidence that this was a scheme on his part so that he could then pull a gun on Mr. Blunt. And I don't think that there's any evidence that Mr. Hall was committing a crime or fleeing a crime when he then used the force. The crime would be the force that he used, if that's what the jury decides. And I don't find that he's the initial aggressor, i.e. he pulled a gun on Mr. Blunt first, but then put his hands up and said, wait, never mind, I'm done with this. And then Mr. Blunt went after him. So I think, and there's no combat by agreement. Ms. Feely, do you agree that all those non-justifications should come out?
Yes.
Mr. Hiles? Or?
Yes, that's fine.
Okay. That's all I had. There's a little bit highlighted on the verdict, but I just need to make sure that the verdict I'm using either has blanks where they write guilty or it's something where you check a box, and I'll make sure that the language in the jury charge fits with the verdict form, and I'll get you all a verdict form soon to review. So what I think we're leaving hanging is what do we do with felony involuntary? And then I need to incorporate excessive force and revenge and defense of habitation. Ms. Feely, anything else?
No, that was it.
Mr. Hiles, anything else?
No, Your Honor.
Okay. Mr. Abate, are you calling any other witnesses when we bring the jury in?
Yes, we'll call one more witness, Miss Angela Northcamp.
Is that a GBI person?
She's a former GBI firearms examiner.
Okay,
Now works independently.
got it. Has anyone from the defense had a chance to, have you offered up a chance to speak with her?
I have not, she just arrived.
Okay. Do you want a chance to say hey?
It won't say take
Okay.
long, but yes.
Before you go do that?
Okay.
Anything, that'll be, then you'll rest, subject to whether you're gonna use the immunity testimony based on what happens with the defense.
Yes, we'll rest. I guess after the examiner testifies, we'll tender the stipulation to the court.
Okay.
We'll rest.
Okay, great. And you expect to cover with Ms. Northcamp, what you've already previewed, which is sort of the basics of how a gun works and, why you might not test one gun versus the other, but whatever it is, it's not the specifics of the facts of this case. Oh yes, those 8 shell casings came from this gun. And I can tell by looking at the other gun that it wasn't fired at the time. It's no case specific analysis.
No case specific other than if, be hypotheticals, if 8 shell casings were tested and they were tested or compared with a Smith & Wesson 40 caliber pistol and someone was a private examiner, an examiner was able to determine that those came from that specific gun. Can you tell the jury why you wouldn't test the second gun against those same shell casings? That nature and individual characteristics from each.
Okay. That all makes sense. Ms. Feely, anything you want to cover before we take a quick break so your team can speak with the state's expert? Okay. So Mr. Hall, that witness won't take very long on the stand. Then the state's going to rest, send the jury out. Once they do that, when I send the jury out, that's when we're going to talk about whether you want to testify. All right? Okay. Then is 5 minutes enough? I just want Deputy Gordon to be able to tell the jurors when to be ready. Okay, if it morphs into something more complicated, just let me know. But let's try to be back in here in 5 minutes. Okay? Will you let them know? Give them 5 minutes. Great.
No, we're not Mr.
She's not out there?
No, she is, that's what we're going through, there's this,
Oh, yeah.
I mean, object to this one.
Okay. Can you let me know in advance so I can be thinking about it? What's the objection?
Improper history. She's literally going to come in here and say if the report is correct. And this is how, why you wouldn't test the second time. And so they've already went through that with Detective Barry. I think even another one to talk about. I think preview was investigator recommended. But it's our position, it's improper altering cumulative of evidence. Sorry, interview.
Okay, well, we'll get that on the record. Gosh, we got a lot of deputies in here all of a sudden. What happened? We got all the top brass. Pardon me? Yeah. I mean, I think she'll come back out. She was just using the restroom. All right, Ms. Rivers, let me know when you're ready. We've got something we need to get on the record. All right, Mr. Abate, can you spell the last name of the potential new witness?
C-A-M-P.
I thought it was Northrop.
Well, from middle, North Camp.
Oh, Camp.
North hyphenated Camp.
Camp.
Camp is her last name.
All right, so Ms. Camp. Ms. Feely, you had a chance to speak with Ms. Camp, and based on that conversation, you have an objection to the state calling Ms. Camp, and so we're clear on the record. Ms. Camp is not a witness who was on the state's original witness list. This last-minute scramble is all necessitated by the fact that Mr. Jarvis is unavailable medically, and we've had a couple fill-ins for Mr. Jarvis, a stipulation. Investigator Rickman has talked a bit about firearms, and Sergeant Barry talked a little bit about firearms, all in an effort to cover some of the ground that Mr. Jarvis would be able to do. But you've got a concern that Ms. Camp would be able to do. You've got a concern about Ms. Camp's testimony.
Yes, it's our position that this is cumulative of other witnesses who have testified about firearms. I think her testimony is going to be, once you've identified the bullets as coming from a gun, then that is enough essentially, which is improper bolstering of the state's case to have another witness come in and say that. We stipulated to the report. We have gun owners on the jury. So I think this is just improper bolstering of the report that's stipulated to.
Okay. Mr. Bata, anything you want to say in response?
Just that she can't say that Mr. Jarvis's report is necessarily correct because she isn't a peer reviewer. She is going to talk about the processes and the procedures and things that people like Mr. Jarvis does in order to come to his conclusion, and then based on his conclusion, what that necessarily means. And more importantly, an email was sent yesterday morning where it says, I don't think the first sentence is necessary given the state is now calling an expert. It is our position the first sentence validates credits tool mark analysis without me being able to cross-examine it. So as a result of that email, she now can cross-examine anything she wants about tool marks and things of that nature with Ms. Camp.
Okay. Now I'll note that Ms. Camp is not Mr. Jarvis, so the jurors will be getting it one step removed. But what I'm understanding the scope of your questioning to be is that it will keep Ms. Camp as an educational expert as opposed to a case-specific expert. And as long as you do that, I'll allow her to testify. I think it is related to the testimony of other witnesses, but this will be the only witness, and that's not cumulative, who's got expert qualifications to talk about these things, as opposed not to suggest Investigator Rickman's not an expert or the sergeant wasn't, but not in that area. In fact, the sergeant had to go so far as to say, This is just what I was told by the experts. I'm not someone who could look at a shell casing and say that came from this gun. This is someone who can, but, and this is the distinction that I think merits the testimony, she won't be saying, and I can tell you these shell casings came from this gun. That's Mr. Jarvis. That's the stipulation. This is the packaging that will come around a testimony from an expert that allows the state to argue what it wants to, but also gives Ms. Feely an opportunity to ask questions about the reliability, the technique, et cetera. I appreciate that for both sides, it's one step removed because it's not Jarvis, but no one is asking this person to say Jarvis did a great job or a bad job. And Ms. Feely would be free to say, could errors occur? And do you have any idea how thorough Mr. Jarvis was? I don't know Mr. Jarvis. So I will allow the testimony as long as it stays away from the specifics of this case.
Yes, her testimony is really about the why and how Mr. Jarvis would be able to come to a conclusion like the one he did in this case.
Okay. Ms. Feely, given that ruling, do you want more time to speak with Ms. Camp? I don't want your concern to be, well, wait a minute now, I'm not sure what else she's going to say. We don't know because she hasn't testified, but I think we all have a pretty good feel for the perimeter of what she's talking about.
Yes, that's fine. And I just will renew the objection to her when she's called. I think I have to.
Sure.
But I understand the court's ruling.
Okay. All right. Anything else, Mr. Abate, before we bring the jurors in?
Nothing other than Mr. House will be sending an email with some case laws relates to the lesser included of felony involved, both the court and counsel.
Great. Sounds good. I'll look at that. Ms. Feely, anything else before the jurors come in?
No, Your
All right, let's bring them in, please. And let's have Ms. Camp nearby.
All right, we'll do it.
Thank you, Deputy Gordon. Everyone else can be seated, please. Welcome back, jurors. Happy Wednesday. Appreciate everyone being on time. I got the word that you were good to go at 1. Our charge conference, that's when the lawyers and I talk about the law that I'll be giving you soon, took longer because there were a couple things that we really needed to work through. I had estimated that a half hour would be enough, so start at 12:30. Drug court ran a little late, so we didn't start till 12:45, and we just finished. But it was important stuff that we needed to work through so you could get a jury charge. But I appreciate everyone being on time. We are still in the state's case. I'm going to ask Mr. Abate if the state has another witness to call.
Yes, Mr. Rao's going to take that.
Mr. Rao, next witness, please.
State called Angela Camp.
And Ms. Feely, it's my understanding you have an objection to this witness testifying.
Yes.
Okay. As we've discussed outside the presence of the jury, that's overruled.
You swear affirm that testimony you will give is the truth, the whole truth, and nothing but truth, so help you God.
I do.
You know, I receive. Can you state your spelling name for the record?
Angela Camp, Angela Camp.
Good afternoon, Ms. Camp. How are you?
Good, how are you?
Doing well, thank you. Ms. Camp, would you mind telling the jurors what you currently do for a living?
I am a high school math teacher.
Prior to that, what would you do?
I was a firearms examiner and expert witness for the Georgia Bureau of Investigation, Division of Forensic Sciences.
And what did you do for the Division of Forensic Sciences?
I was a firearms and tool marks examiner, And I would examine evidence such as bullets from autopsies or cartridge cases found on the scene and compare them to firearms. If I identified a firearm as having been used in a crime, I would do a full check function on the firearms. I also assisted with training new examiners. I specifically did class characteristics training and revolver block training, as well as mentoring new examiners coming onto casework and some courtroom training as well.
And how long did you do that for?
Almost 6 years.
And would you mind, when did you leave the GBI?
March of this year.
With respect to the knowledge, training, and experience that you would have had in order to do the job that you did at GBI, can you educate the jury as to that?
I have a bachelor's degree of biology from the University of Georgia. Once I was hired with GBI, I underwent a 17-month training program with GBI, where I learned ammunition manufacturing and development, firearms manufacturing and development. I learned how to restore serial numbers if they've been removed or obscured. And I learned how to tell how far away a target was from the muzzle of a firearm at the time it was shot. In addition to that, I spent most of my time during that training period on a comparison microscope, which is 2 compound microscopes combined by an optical bridge. So when I look through my eyepieces, I can see what's on my left stage and my right stage at the same time under the same magnification. So what I used that for was I would compare bullets to bullets and cartridge cases to cartridge cases to determine if they were fired from the same firearm. In addition to that, I successfully completed multiple certified armors courses with Glock, FN, Smith & Wesson, and Springfield. And I was a member of the Association of Firearms and Toolmarks Examiners.
And during the course of your time in employment with the Georgia Bureau of Investigations, how many pieces of evidence or how many times would you say you had to analyze ballistics evidence and generate a report?
That's not something I tracked. However, based off of monthly and yearly averages, I'd say probably around 400 to 500 cases, not cartridge cases, individual cases.
And with respect to the qualifications as an expert witness, have you ever been qualified as an expert witness in the field of firearms examinations?
Yes, I have.
How many times?
42.
At this time, the state superintendent, Ms. Camp, as an expert in the field of firearms analysis and examination.
Ms. Feely, do you have any objection to such qualification? Not this witness testifying, but being qualified as an expert in the field of firearms examination?
No, Your Honor.
All right, Ms. Camp, even though you're now a math teacher, we're qualifying you as an expert in the field of firearms examination for the purposes of this trial.
So I guess to ask you a generic question, would you mind telling the jury how do you do what you do?
So I'll begin with describing a cartridge, if that's okay. So a cartridge is a single unit of unfired ammunition. If I have a firearm and I want to shoot it, I'll go to the store and buy a box of cartridges. Cartridges consist of 4 major components. There's the cartridge case that holds everything together. And then the bullet is seated into the cartridge case. The bullet is the part that most people think about. It's the part that will travel down the barrel of the gun when it is fired. Within the cartridge case, there's gunpowder. And at the top of the cartridge case, there's primer. So when a firearm is fired, a firing pin will strike the primer. It'll cause a spark that will ignite the gunpowder within the cartridge case. Pressure will build. The bullet will be sent down the barrel. Well, for every action, there's an equal and opposite reaction. So the cartridge case, when the bullet goes down the barrel, the cartridge case itself is slammed against the back of the firearm and swells up against the walls of the firearm. So all of these things are leaving markings from the gun, which is the harder metal, onto the softer metal of the ammunition because of the high forces. So my previous job entailed looking at these markings from the firearm. There are 2 different types of markings that we would generally look at. The first one is the more general one. So if I have 10 models of the same model firearm, they're all going to have the same class characteristics. Class characteristics are design features. What was the shape of that firing pin and how was it made? The insides of the barrels of firearms are rifled. That means there's spirals that will be cut or squeezed into the barrels of the guns. And the purpose of that is just to make the bullet more accurate and go further. However, different manufacturers will use different types of rifling. They can have 5 lanes and grooves with the right hand twist, 6 lanes and grooves with the left hand twist. Different manufacturers will kind of do this different things. So if I have 10 guns of the same model, they're going to have the same class characteristics. However, the second type of characteristic that we look at is individual characteristics. And individual characteristics are random microscopic imperfections that that specific firearm had when it was being made. So if you think of all of the manufacturing processes that one gun had to go through to become a firearm, there were so many metal on metal interactions with so many different tools that at the microscopic level, it left imperfections. And when you fire, sorry, my mouth's drying out. 1 second. When you fire the softer ammunition into the firearm, the ammunition will pick up these marks and they'll repeat. So you can look at the ammunition and look at the individual characteristics that were left from the firearm to determine if they were fired from that gun.
So as I understand it, there's 2 separate types of characteristics that you all look at. Class characteristics, which would be consistent with guns of similar makes and models, and then individual characteristics, which would be different regardless of whether or not those 10 different firearms were all of the same make and model.
Right. So the individual characteristics are unique to that firearm. The class characteristics are shared, just design characteristics.
And does each firearm, each handgun have its own individual characteristics that it will imprint upon a cartridge?
Yes, it does.
And it would be unique to that particular firearm and no other firearm?
Correct. The individual characteristics are random imperfections during that manufacturing process of that specific firearm.
So with respect to, I guess a hypothetical that I'll present to you, if 8 shell casings were recovered from a crime scene and 2 firearms were recovered from a crime scene, one being a Smith & Wesson 40 caliber and one being a Glock 22 40 caliber handgun. The Smith & Wesson was submitted for testing and compared against the 8 shell casings, and a comparison was done to match those shell casings to the 40 caliber Smith & Wesson firearm. Would it be prudent or reasonable to submit the Glock 40 caliber firearm for testing to compare against those 8 shell casings?
Once a group or one cartridge case or multiple cartridge cases, once a cartridge case has been identified as being fired from a firearm, it will not be compared to another firearm, typical procedure of the GBI.
And would that also be true for any projectiles recovered from the scene?
Correct.
Now, do you happen to know who Jay Jarvis is?
I have met him, yes.
And how do you know Mr. Jarvis?
I've seen him around the firearms section of the Georgia Bureau of Investigation.
Was he employed there at the time?
Not at the time that I was.
Were you aware of his employment with the GBI?
Yes, he used to hold a position similar to mine at the GBI.
Can you speak to the individual class characteristics or differences that, if any, were to exist between a Glock and a Smith & Wesson?
Depending on the model, I'm very familiar with Glock class characteristics, and I'm very familiar with Smith & Wesson characteristics.
I'm going to present you with what's already been admitted into evidence as State's Exhibits 164 and 163. 163 being the 40 caliber Smith & Wesson, and 164 being the 40 caliber.
For the record, the Glock is unloaded, as is the Smith & Wesson. Yes. Thank you.
Ms. Camp, when reviewing those firearms, are you familiar with those particular firearms?
Yes,
And how are you familiar with those particular firearms?
I have analyzed many Glock 22s and many Smith & Wesson Shields.
Can you speak as to the differences between the individual and class characteristics between those two firearms?
There are many differences in the class characteristics. The shape of the firing pins are different. The Glock 22 Gen 4 is going to have an elliptical shaped firing pin, and I can see the aperture right here. It is rectangular in shape, which is something that the cartridge cases will show when they're fired in it. And the M&P Shield, I'm familiar with their manufacturing processes of their firing pins, and they are not elliptical. They are hemispherical, and then there's a little line through their firing pins as well that show up on the cartridge cases. Also, the firing pin aperture is what we call teardrop in shape. It is not rectangular. So the class characteristics are very different. So any cartridge cases that have similarities to one or the other would not warrant a comparison to both. So let me restate, if I have class characteristics that are similar to the Glock, then I would not even compare them to the Smith & Wesson because they're just entirely different shapes. If I have cartridge cases that are consistent with the class of the Smith & Wesson, I would not even compare it to the Glock because I can see it right here. I don't even need my microscope to see that the shapes are different.
So despite being both weapons of the same caliber, why would they have different class characteristics?
The manufacturers chose different manufacturing methods.
Thank you, Ms. Camp. I appreciate your time.
Ms. Feely?
Thank you. Your qualifications are very impressive. You said you had a 17-month training course?
Yes, 17 months training followed with 6.5 months of supervised casework.
That was and then was there 17-month training as well?
Before the 6.5 months of supervised, yes.
And you said 400 to 500 cases like this, right?
Approximately, yes.
And when you were at the GBI, you would get cases from police departments, is that right?
Yes, police departments would submit evidence. Also, DA's offices could, and medical institutions could as well.
And that would include the Atlanta Police Department submitted separate testing, right?
Correct. Sometimes the Atlanta Police Department did submit evidence.
And the Fulton County District Attorney's Office also would send stuff to be tested, right?
Yes, they could as well.
You didn't test any of the firearms in this case, right?
No.
That it?
Yes, thank you.
Okay. Anything else, Mr. Rao?
Speaking of Judge, you just left the GBI earlier this year, is that correct?
That's correct.
Are you aware of a backlog that exists within the GBI?
Before I left, there was quite a backlog, yes.
You happen to have an estimate as to the timeframes that you or members of your department would have had to provide a law enforcement agency or a district attorney's office with respect to the turnaround of a request for firearms analysis?
At the time that I left, when a case would come in requiring expedite, please work this right away, we need it. Typically, the expedite wait list from the time around the time I left was at least 3 months. There was quite a backlog.
What was it if it was not an expedite?
I cannot estimate that.
Okay.
And certainly it wouldn't have been feasible, or would it have been feasible for every piece of firearms evidence submitted to the GBI to have an expedite request that you could fulfill?
It was not feasible. We were very short on manpower at the time. There was a lot of scientists in training when I left.
Being at the GBI as recently as this past March, were you aware of law enforcement agencies or district attorney's offices seeking the employment of private contractors to examine firearms evidence?
I had heard of things like that happening.
Thank you. I appreciate your time.
just very,
Yes, ma'am.
the case happened, as the state gave you hypothetical, in April of 2022. It's safe to say that if a firearm was submitted at that time, it could have been tested in a murder case prior to trial, if the trial was today. Is that fair? April 2022 to today?
Potentially. It depends on the backlog and just conversations, I suppose.
But you can't ask for us to add it.
You can, however, there was a wait
3 months, right?
about.
Do any of the jurors have any questions for Ms. Camp? Deputy Gordon, springing into action. Thank you. Lawyers? I'm asking Mr. Rao to put a photo up. I'm going to ask you some questions about, but while he's doing that, could the same rounds be fired from the 2 guns you have in front of you?
They are the same caliber. So if I were to buy a box of 40 caliber cartridges, I could shoot them in both.
Good. That was a better way. I didn't mean, could you fire a bullet once and then try to stuff it back into the other gun and shoot it again? If I had a box of 40 caliber, I could drop rounds into both. And assuming the guns are working, both guns would fire the same kind of rounds.
That's right.
Okay. If you look on your screen, you can move that box a little bit out of the way. No, press stay mute. Press the stay mute This is something that's already in evidence. And the question is, can you help the jury understand why a firearms examiner might be able to determine if the item to the far right, says left shoulder on the sticker that's below it, why that might be accessible to see was it fired from a known firearm, whereas the other two could not?
Correct. Okay, so when we are determining whether or not a bullet was fired from a particular firearm, we have to see the rifling that it encountered. We have to see what is called the bearing surface of the data from the gun. May I stand up?
Sure.
Okay. So I would have to analyze them myself to say whether or not these are ammunition evidence. Looking at this, the long side here.
So I want to make sure you're not going to offer an opinion as to what kind of gun fired it, because that's not the question and not your role. Otherwise, keep going, please. All right.
The long side here is what will come in contact with the rifling of the firearm. Now, if this is an ammunition component over here, they may have been the base, which is like this bottom part, that would not have interacted with data from the gun. Otherwise, I would have had to analyze it, and I did not. However, this long side here is the part that we would be looking at, firearms examiners would be looking at to get all the information from the barrel of the gun. It's the part that would actually contact the barrel of the gun.
Thank you. Mr. Rao, do you have any questions for Ms. Camp based on that?
When examining, I know you spent some time talking about projectile. When examining a shell casing, what are sort of the things that you look at to determine the characteristics as to whether or not it's fired from a particular make or model or a particular firearm?
The characteristics that I will look at when I'm determining if it was fired from a particular model are those class characteristics. So they will be the shape and the location of the extractor and the ejector within the firearm. So they're just pieces of metal that will interact with it. Mostly it will be the firing pin impression, the shape of that firing pin that actually struck the primer. In addition to that, we can see markings of the hole. I was calling it earlier, the firing pin aperture, the shape of the hole in the back of that gun that the firing pin will travel through. And that will tell us a lot of information about what type of gun fired it. And then we'll look at breech face marks as well, which will tell us about how that the back of the chamber was milled out or however it was made.
And during the course of your time when you were actually examining firearms evidence, did you ever come across fragments that you were asked to analyze?
Yes.
And would you mind explaining to the jury what a fragment is in the context of firearms evidence?
Typically, for fragments that I would classify as fragments, they would be pieces of projectiles, whether it's the jacket itself, like the brass color we saw earlier, or lead within the jacket. Those would just be potentially fragments.
And in your experience, knowledge, training, and experience, and in your time at the GDI, is it uncommon for you to receive a projectile that's not intact in the manner as the projectile that you were pointing to in front of the jury?
No, quite common. I would encounter projectiles that were not very intact. When they are leaving the gun, there's quite a lot of force. So whatever it hits has the potential to deform it.
And a fragment that's deformed, is it uncommon for you not to be able to make any sort of determinations as to the class characteristics or individual characteristics of that particular fragment, such that you can render an opinion on it?
It was not infrequent to have so much damage that there were no conclusions drawn.
Thanks, ma'am. I appreciate your time.
Ms. Feely, anything else?
No, no.
All right. Thank you, Ms. Kemp. Appreciate it. Mr. Abate, next witness.
Your Honor, at this time, the state would tender State's Exhibit 172 stipulation agreement between both defense counsel and the state, signed by the state as well as defense counsel, Your Honor.
All right, Ms. Feely, any objection to the admission of State's 172?
No, Your Honor.
You can read that into the record and then it will be an exhibit that the jurors can examine during their deliberations.
Thank you, Judge. Analysis performed by firearms analyst Jay Jarvis demonstrated conclusively that the 840 caliber shell casings recovered from apartment number 2 at 537 Sunset Avenue, State's Exhibit 161, and the 40 caliber metal jacketed bullet recovered from the left shoulder of Corey Blount, State's Exhibit 165, were fired from the Smith & Wesson 40 caliber pistol with serial number obliterated, State's Exhibit 163.
Thank you. That's in the record. And your next witness.
Your Honor, at this time, the state of Georgia rests.
All right, ladies and gentlemen, we have reached a natural break point. And I'm going to have you retire to the jury room, hallway, wherever you want to be. The evidence is not necessarily closed. I have to talk with the lawyers because we've reached this juncture, and then you're going to come back out and I'm going to ask Ms. Feely if the defense is going to present anything. They don't have to. I've told you that a bunch of times, but they have an absolute right to if that's the defense strategy. So I'm going to bring you back out here once I've had a chance to talk with the lawyers. But you don't necessarily have all the evidence, which means don't start your deliberations, no outside research, don't talk about the case. This break shouldn't take too long, but I promised you that before, so we'll see what happens. Don't go far. Thank you.
All right, adjourned.
All right, you all can be seated. Ms. Feely, do you have any motions at this time? Okay, I understand that. Then let's turn, Mr. Hall, to the conversation I told you that you and I were going to have. Are you ready to chat? Do you understand, Mr. Hall, that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Yes, Your Honor.
Do you understand that in the same way, no one can compel or force you to testify? That is, you have a right just as powerful to say, I am not going to testify.
Yes, Your Honor.
Do you understand that you and not either of your lawyers will be telling me in just a moment whether you're deciding to testify?
Yes, Your Honor.
Do you understand that if you do not testify, then I will instruct the jury that they are to draw no conclusions or inferences or really consider it in any way during their deliberations?
Yes, Your Honor.
Do you understand that if you choose to testify, you'll be subject to cross-examination, meaning it won't just be the questions from Ms. Feely, which are more along the lines of, and then what did you do? But there will be questions that are more argumentative, but legally so, from the prosecution that can press you in directions you may not want to go, but if they are proper questions, you must answer them.
Yes, Your Honor.
All right. Understanding all that, Mr. Hall, do you wish to testify in your case?
No, Your Honor.
I find that Mr. Hall has made his decision not to testify with a full understanding of his rights. I will instruct the jury that they are to not consider in any manner the fact that Mr. Hall did not testify. So we are at the crossroads now for the state. Mr. Hall is not testifying. Oh, Ms. Feely, were you going to call any other witnesses? All right. So when the jury comes back in and I ask you, are you going to present any evidence? You'll say the defense rests. I've already made clear to both sides that I would allow the state to reopen the evidence if it so chooses, although only for the purpose of playing some of Mr. Hall's immunity testimony. What is the state going to do?
Like 30 seconds.
You can have more than 30 seconds.
Taken off to not like Mr. Hall's testimony or the testimony that was given during the May 22nd immunity hearing that Your Honor heard and eventually denied.
Okay, so when Ms. Feely rests, assuming that's what she persists in doing, then the evidence is closed.
Yes, Your Honor.
Then we should talk now, because this has gone quickly, a little bit more about involuntary manslaughter. I hadn't quite finished reading the first case the state sent was very much on point, but on in favor of a ruling I made for them. I think, I'll get this in the record, that given the cases of Keller versus State 253 Georgia 512 and its predecessor back in an earlier version of the evidence code, Appleby versus State 247 Georgia 587, that if a defendant is advancing the defense of justification, i.e. self-defense, he is not entitled to an instruction on what we've been calling misdemeanor involuntary manslaughter, i.e. lawful act performed in an unlawful manner. That is not a jury charge or a lesser that is available to someone who wants to pursue the defense of self-defense. So I'm not going to give that unless you're telling me that you are abandoning self-defense and would rather pursue lawful act in unlawful manner.
Usually we're talking about misdemeanor.
Yes, ma'am. The second of the two involuntaries, it's 1653B, but it's unlawful act in, it is lawful act in unlawful manner. That is a misdemeanor. In other words, if Mr. Hall were found guilty of this form of involuntary manslaughter, it would be a misdemeanor. And the Supreme Court has said on repeated instances, not reversed by MacGyver, that if the defense is self-defense, not accident, but self-defense, then that is not an available lesser included. That was the first email that Mr. Heil sent. That's not responsive to the debate about reckless conduct and felony misdemeanor. He sent a second one. I haven't read that yet, but I wanted to give you a chance to get anything you want on the record in connection with the misdemeanor version of involuntary manslaughter.
Was it error to give it?
The involuntary? Because I don't think it would be error to err on the side of caution and give them the charge. And that's our request.
Okay, let me look. I know that it's Appleby versus State, so it must have been that it was not error not to give it. But more so, it says, and I'm reading from Keller, which is the newer of the cases, involuntary manslaughter under OCGA 1653B, Bravo, is not available to a defendant who uses a gun in self-defense and kills as a result. So then it goes on to say the trial court did not err in refusing the suggested charge. But that first sentence tells me that it would be error to give it. More importantly, it's not error not to give it, so I'm not going to give that one. You can maintain your exception to that, but I believe that Keller and Appleby both stand for the proposition that those are actually sufficiently legally inconsistent as opposed to factually inconsistent defenses that the court ought not to charge on lawful act in an unlawful manner, involuntary.
Understood. We're still requesting it, but we understand the court's ruling.
Okay, that shifts us to felony involuntary, in other words, premised on reckless conduct. And that case that Mr. Heil sent is called Craw, but it's a Court of Appeals case. All right, I have reviewed Bennett versus State 254, Georgia 162, and Williams versus State 301, Georgia 712. I found Bennett through CRA, the Court of Appeals case. Both those cases, Williams and Bennett, stand for the proposition that the intentional use of a gun, the deadly force of which is known to all, is simply inconsistent with the lack of intent to kill, which is a prerequisite in involuntary manslaughter. That's a quote from actually Harris versus State 272, Georgia 455, which is cited and quoted in the Williams case. So we've got Bennett, Williams, and Harris, all of which say when the defense is self-defense and there's no evidence of an accidental discharge, but that there was a purposeful shooting at or in the direction of the ultimate victim, then it's not reckless conduct, and there is not the charge on felony involuntary, so that's 1653A alpha, is not warranted. So I will not be charging on 1653A either. That's the one where we were still having a dispute. My ruling on 1653B was reaffirmed by Keller and Appleby. I was less certain on A, the felony version of involuntary manslaughter, but this case law is clear and supports the frustrated argument that Mr. Abate made. I do want to hear from you, Ms. Feely, because I am now not going to include something that you requested.
Yes, and it's our position that is very problematic because I understand what you're saying about self-defense, but before we even get there, the state has a burden of proof, and one of the elements is intent. So the jury, to take away from the jury an opportunity to consider whether the state proved intent, because that's in the statute, is, I think, should, I think it's problematic. I think it's.
What is the evidence or lack of evidence in the record that Mr. Hall did anything other than intentionally fire 8 times through the door of apartment 2?
He told Detective Barry he didn't intend this to happen. And it's still an element that the state has to prove beyond a reasonable doubt, and I don't think they've done it in this case. And so it's not like what evidence I presented of it or lack of it, it's what the state's presented.
Mr. Abate, what's your response to that? In the Williams case, Williams admitted that he shot the victim, but he said it was self-defense, and then even more so, it was kind of reckless, and he wanted the felony involuntary, not given, not error, not to give it. But the difference is Williams admitted that he intentionally shot the victim. I don't think we've got that here. There is evidence of intent, but you have to prove that.
Yeah, my recollection is that he said during that phone call that he shot at him as he was going out the door. He went for his gun, got it, and shot at him as he was leaving the door. Made it clear that he intended to get his gun and shoot Mr. Blunt. He never said that he didn't intend to shoot him. I think there was a comment about he didn't intend and know that the victim was going to come into the house, but he never made a comment on intending not to shoot Mr. Blunt. And furthermore, during that conversation, Miss Stuckey says to him, you know, you killed that boy. And he said, I don't remember his exact words, but it was something along the lines of, okay, it wasn't, I didn't intend to do it. I didn't mean to do it. I'm sorry for doing it. It was an accident. He just said, okay.
Judge, the language of the case, it cites that everyone knows that the deadly nature of a firearm, I think illustrates it is an intent to shoot, and why it's not.
But the language in there is that the intentional use of a gun is inconsistent with the lack of intent to kill. But I don't know that that's necessarily a accurate statement. It's what important judges have said, but people fire guns all the time, not intending to kill. And the state has the burden of proving that intent, either directly or through circumstantial evidence or the abandoned and malignant heart. I don't think it's hard for the state to do that. I don't think the jury is going to struggle with this. I don't want the Supreme Court to struggle with it if it's a conviction and a lesser included wasn't charged. And I don't think we've got evidence of Mr. Hall saying, yeah, I intentionally shot him. I don't think there's any evidence that he accidentally fired the gun, but he fired at a door, and he should have known who was behind that door. He could have shot Miss Stuckey, frankly, the way he was shooting, but the state has to prove that he intended to kill. We don't presume that.
I think it's his intent to shoot him that makes involuntary an issue. And he definitively says in his own words, I shot him as he was leaving the door, as he was going out there. I know he has.
So play that for me, because that was so hard to hear, and you guys are hanging a lot on something that jurors asked questions about. I could not hear what was being said when that happened, and so I don't want to assume that the jurors ever heard that.
While he's queuing that up, I had another case, McClure versus the state. It's Georgia Supreme Court, 306 Georgia 856 from 2019. And I think it talks more detail about the slight evidence that's needed to justify a jury charge.
I'm familiar with McClure and the slight evidence. You're stuck in a position of actually arguing the reverse, that, I mean, the state has this burden to prove intent. I think there is slight evidence that, and you could argue, I don't know that it will be a great argument, but you could argue he just wanted Mr. Blunt to go away. And so he fired into the door to make it clear Mr. Blunt shouldn't come back. I don't know how persuasive that would be, but I don't think that that is with no basis in evidence. And so if you could argue that, then it strikes me that felony involuntary ought to be given, because what differentiates the cases I cite is that there the defendants were all admitting, I shot the guy. Of course I shot him. He was coming at me with an axe. That's not the, but yes, I shot him. Whether the defendant took the stand or in some hearing, there was evidence before the jury where a defendant said, I meant to shoot the guy, but it was self-defense. And they wanted to layer on top of that, well, actually, it was just reckless conduct. And in that setting, the appellate courts have said, you don't get that charge because you have owned the intent to kill. And either it was justified or it wasn't. And this isn't that case.
Understood.
So I'm happy to listen to this phone call if you can make it play and make it audible. But I don't think we are in the framework of Williams and Bennett and Harris.
Judge, while Mr. House is pulling that up, can't remember the state's exhibit number, but with respect to the surveillance video, 123, you observe the individual in the blue shirt that was identified as the defendant saying, "I shot that man who pulled a pistol out on me. I shot that man who pulled a pistol out on me," said twice. So in support of the state's position that the defendant did in fact use the language that's used in the framework, Your Honor, in the cases that Your Honor cited, that would also go to substantiate why an involuntary would not be an appropriate charge.
Okay.
Your Honor, is there a new Zoom link for today?
There is.
There too. And Your Honor, I've watched that video a lot of times and I don't remember hearing him say, "I shot that man." There is somebody in the background that says something about "shot that man," but it was not him. And I'm frankly concerned that there's going to be argument to this jury of things that were not actually admitted at this trial.
Well, both sides are free to share with the jury their recollections of what the evidence was. I'm confident the jurors are going to want to watch those videos again, and they'll make their own determination of who said what, what's audible, et cetera. I need to make sure I'm not basing a jury charge ruling on what may be audible in the videos.
Understood. And I don't know of a case where it's ever been aired to give the charge.
Okay. So you got a few more seconds.
I got it. I'm logging into the Zoom so I can play it. I have it queued up.
I guess while you're looking that up, Mr. Bate, do you need a few minutes to get the equipment set up for your closing? Do you want to start doing that?
Yes.
Okay.
I was just gonna make sure I could share video. Is it appropriate for me to do that now?
Share a video.
Just my screen, just share screen. I just want to try it, make sure.
Oh, sure.
Thanks.
As soon as you do that, we have that queued up. Shoot.
Okay, you do that first then.
Okay.
Why don't you try sharing your screen? I'm getting to see your script from Shubo.
Oh,
It's gone.
can't have that.
Yep.
But you can see it, okay.
Yeah, I mean, you can look on the screen there. Are you showing what you want? Okay,
Yes.
great. All right. You want to try again, Mr. Hiles?
Yes, Your Honor. All right, I'm gonna share about 45 seconds before we get there, but that's as close as I'm gonna get without.
Okay.
All right, this is on the minute marker 3:18:06.
So he came out of nowhere, and I'm like, bro, I said, what's going on? What's good with you? He pushed up on me and pulled a gun. I had a gun in his hand. So I backed back. I'm like, you know what I'm saying? So I backed back. I didn't know what was going on. He came out of nowhere now. I didn't even know he was out there. I didn't call him over there. They called that man over there. I guess trying to check me or something. I didn't even know he was out there.
Do you have no idea why he came to the apartment in the first place?
They called him over there.
And you said some folks was knocking on the door?
Yeah, some people knocking on the door, but it was some neighbors and stuff.
What they want?
I don't know what they want. They was like knocking on the door. They was the neighbors and stuff knocking on the door. They was some weed. So I told them, I'm like, stop knocking on this door because I don't even know these people. So we could have moved over there. They was just knocking on the door all times of the night. So I went down there, knocked on their door and told them stop knocking on this door. So I don't know who these folks is. So he came up there. They called him. I don't know. I don't even know him. This man came up. I said, you good? You all right? He put something to me. You good? You good? I'm broke as hell. And he would come to my house and try to be aggressive with me. I don't even know him.
So what happened after he pulled out his gun?
After he pulled out his gun, he walked towards the door. He walked back towards the door, but I was right up by the couch. I had my gun right there. So I just shot him because he put the gun out on me. I don't know where he came to. But if y'all see.
Said clearly right there that I backed towards the door, or he backed towards the door. I was at the couch, already had my gun. I just shot him.
That's what you think you heard.
Then he says he was going up the door, I shot at him because he pulled a gun out and it was unexpected.
Okay. Ms. Feely, anything you want to say in response?
No, we're just asking that the charge be given.
Okay. All right. Keep setting up your PowerPoint, please. He was gone. They were in the car together. She knew he had a gun. I think he couldn't ride in the car with a gun. Is it not working?
We can get started if the court, after Ms. Feely finishes her closing, if we can take a break, and we'll
Right, as long as it's waiting right out there. Okay, so you can do the first part of your PowerPoint, just push it through Zoom?
Yeah, Mr. Allison, the first part of PowerPoint's got no videos, sir. It's just PowerPoint.
Okay, is that back into Zoom rooms?
Yes.
Okay. Does Mr. Hall need a break or is he good?
This is good.
Okay. All right, so you're ready to go with part one of the closing?
Yeah.
One of you is, all right. And then Ms. Feely, you'll be ready to go after that because the jurors are not gonna, Rivers may need a break and I'll check with her, but the jurors are not gonna need a break after the first part of the state's closing. I am not, NOT, going to give involuntary manslaughter, unlawful act in looking at more of the case law. The distinction I draw is not whether there is evidence of Mr. Hall's intent, or really, is there any evidence that he didn't intentionally do it? Actually, my finding is that there's not a misdemeanor that he committed. When he fired 8 rounds through that door, that is at a minimum an aggravated assault committed against Mr. Blunt, because it was the use of a deadly weapon directed at or in the direction of Mr. Blunt. He doesn't need to have hit him for it to be an aggravated assault. So there's not a misdemeanor that would serve as the predicate. Put differently, I don't believe the evidence supports that it was reckless conduct to shoot 8 times through the door where Mr. Blunt had just been standing. I think that that's an aggravated assault. And if there is no misdemeanor to support felony involuntary manslaughter, the 16.5.3a, then it shouldn't be given. I think it's a close call anyway on the whole intent piece, given that the defense is going to be self-defense. I just don't, there's not a case that says as precisely, if you argue self-defense, you cannot categorically argue felony involuntary. Most of the cases are the defendant testified on the stand that he intentionally shot someone. That's not involuntary manslaughter. I didn't find a case where the evidence is he intentionally shot the person. But I do find that the shooting at and in the direction of Mr. Blunt, and frankly, Ms. Stuckey, and none of this has to be charged in the indictment. It's the conduct of which there is evidence and to which Mr. Hall has unequivocally admitted would be aggravated assaults and not reckless conduct. So I will not be charging on either form of involuntary manslaughter. You've accepted to that, so that's preserved. And we'll see if the Supreme Court can stick to its precedents or not on that one. Anything else, Mr. Abate, in connection with the jury charge? Okay, I'll get a verdict form for everyone to look at. Ms. Feely, anything else in connection with the jury charges?
No.
Okay. Then let's bring the jurors in, please.
All right, so jury.
Thank you, Deputy Gordon. Ladies and gentlemen, when we were last together, the state had rested. At this time, I'm going to ask Ms. Feely if she will be presenting any evidence on behalf of Mr. Hall.
At this time,
Okay. Ladies and gentlemen, the record, the evidence is closed in the case. What remains before you can begin your deliberations is, number one, the closing arguments or summations from the lawyers. Because the state has the burden of proof, they have the ability to open and close their closings, meaning in a moment, I believe it's Mr. Rao is going to get up and give you the first part of the state's closing argument. He will sit down at some point, and then Ms. Feely will have an opportunity, should she choose to present a closing argument or summation on behalf of Mr. Hall. When she's done, then the state will have a chance to rebut that. In other words, they get the last word. Once those closings are done, we'll see what time it is, And if there's enough time, I may give you the jury charge. It may be that it's late enough that I have you go home. And the first thing we do in the morning is give you the jury charge. It doesn't make a whole lot of sense to charge you and then you leave. It makes more sense to charge you just before you begin your deliberations. But let's see what time it is when the lawyers have finished their closing arguments. And a reminder, what the lawyers are about to share with you is not evidence. It is a perfectly appropriate attempt to persuade you to decide the case in one direction or another. You decide what the facts are. If a lawyer tells you, by golly, it was raining that night, and you look at all the pictures and everything and say, I really don't think it was raining, you're free to decide that it was not raining that night. But you're also free to be persuaded by the arguments that you hear from these lawyers. Mr. Rao, when you're ready.
Good afternoon, ladies and gentlemen. Interesting ways. Now we're here at the conclusion of it all. And essentially, what we are going to ask you is make a determination in this case as it relates to your verdict in this case. And to make that determination, you have 4 charges before you that you have to decide on as to whether or not the state has proven its case beyond a reasonable doubt, which we'll discuss what that actually means shortly. The 4 charges here that you have before you decide under a verdict on are a murder, felony murder, aggravated assault, and possession of a firearm during the commission of a felony. These 4 charges that the state would contend we have proved beyond a reasonable doubt and it is guilty. So, as I indicated, I'll explain what our burden of proof is, which is beyond reasonable doubt. It's a phrase that probably many of us have heard throughout the course of our lives, but probably never really had explained to us unless you've been in a setting like this. So, what is beyond a reasonable doubt? I can start by explaining to you what it's not. It's not beyond all doubt. It's not beyond a mathematical certainty, and it's not a vague or arbitrary doubt. It's exactly what it's defined as, a reasonable doubt. The legal definition of which is the doubt of a fair-minded and impartial juror honestly seeking the truth. Now, a lot of you, I think, when we were asking questions during the voir dire process, I think I asked you, Mr. Abate, Mr. Hiles, may have asked you, do you think you can be fair and impartial? Well, all of you are here because you can be just that. Fair and impartial, and honestly seek the truth, as is required of you when you go back there and deliberate. And if you do, in fact, have a doubt, if a doubt does exist in a juror's mind, it must be based on common sense. It can't be like, oh, well, isn't it possible? Well, no, you have to look at the evidence in the case and make a determination. Is it reasonable to see it this way? Is it reasonable to see it that way? So one way I like to describe to jurors as what specifically reasonable doubt is, how you conceptualize it. It's the difference between what's possible and what is reasonable. Now, a lot of us throughout the course of our lives have heard the phrase, well, anything's possible. And certainly that's true. There is some truth in that. Anything is possible. But in the legal setting, when making a determination on a verdict in a criminal case, that's not the standard. The standard is what is reasonable. So certainly anything is possible, right? But is it reasonable in this particular case? And that's ultimately what you are going to have to decide on when you go back there to deliberate. Is what is reasonable based on the facts and evidence presented to you throughout the course of this trial. So part of your duty is to honestly seek the truth. It's not going to be seek doubt. It's not going to be seeking what isn't there. Rather, making a determination on what was presented to you throughout the course of this trial and deciding whether you can make a decision in this particular case. It's not about what doesn't exist and what hasn't been brought towards you for your consideration in this case. It is based on what has been presented to you. What is the determination in this case? So there are things that you can and can't consider as a juror when you go back there and deliberate. And so we start with the things that you can't consider. It's these things that I've listed out in this paragraph. It's not sympathy, it's not conjecture, it's not dislike of the police. You didn't like how the police investigated the case or how the police responded to the case, or if you didn't like any particular individual that testified before you. It's not about those things. It's not about sentiment, it's not about sympathy. I think some of us saw the witnesses, and it's natural to have sympathy in the case of what they endured. But it's not about these things. It's about objective factors that you can then use and apply when you go back there and deliberate. And so the things that you can consider and should consider are the elements of the crime, or the defendant's been charged with 4 counts in this particular indictment. And so I'll explain some of the elements that you have to go back there with you as it relates to each offense that the defendant is charged with. It's based on the testimony and credibility of the witnesses that the state presented before you in proving its case, based on the law that the judge ultimately will provide to you upon the conclusion of both sides' closing arguments, as well as just the general evidence that's been presented to you. Witnesses, photographs, expert witnesses through Dr. Sullivan, as well as Ms. Camp, who were able to present to you their expertise in their specific field. And most importantly, ladies and gentlemen, the thing that I always tell that you have that's your biggest tool when you go back there and deliberate is your common sense. It's something that all of us have, and it's why we're all here, and why certainly you, ladies and gentlemen, are on that side of the courtroom, because you do have common sense. And so you can apply that common sense to the facts and evidence in this particular case and make a determination as it relates to your verdict, whether the defendant did or did not commit the charges that he's charged with. You use that, you apply that common sense to the evidence. And there are 2 types of evidence generally in trials where cases are brought before jurors, and that's direct and circumstantial evidence. Direct evidence is defined as evidence that points immediately to the issue. It's witnesses coming in here testifying as to what they directly observed in the moments that they observed it, and then are relaying that to you through the course of their testimony. It's photographs, it's people's statements that you can hear. Those are examples of direct evidence. Circumstantial evidence is when you have a whole set of facts and you are then able to infer a different fact from those set of facts. And to kind of give you an example of what circumstantial evidence is, and why it can be used to talk to jurors about this particular subject matter, is all of us who have had to drive a vehicle, have had the unfortunate pleasure of having to go to a gas station to fill gas. And so eventually, if you're anything like me, you wait till the very last moment before you have to go fill gas. And so when the meter reads closer to empty, you know that at that point in time, you will have to go to a gas station, stop at a pump and fill up gas. So in this particular scenario, you do just that, pull up to pump number 8, let's say, get out of the car, insert your credit card, choose the grade that you need for the particular vehicle, and you put the nozzle into the tank, and then you hold onto the lever, and then you look at the pump and you see the number of gallons is increasing. You certainly see the number of dollars increasing. And all the while you're just standing there listening to gas meter go in the car. And eventually it will stop. You put the nozzle back into the pump, you'll get in your car, and you'll drive off. Now, you actually haven't seen gas go into the car. You've not actually observed it go into the car, but what you have heard is something associated with gas going into the car. you may have smelled something that you attribute to gas in the area. And as you're driving off, you realize that the meter isn't reading empty, it's reading full. And even though you physically have not seen gas go into your car, you are able to make the determination based on a series of facts where you are, which is a gas station, the smell that you have, the fact that you've had to pay a lot of money to get gas in the car, the fact that the number of gallons went from 0 to 17, 18, 20, whatever. And the fact that you're continuously able to drive is all circumstantial evidence that you put gas in your car, even though you did not see gas go into the car yourself. And that's very true for really every juror in this particular case when they're being asked to decide on a case. They themselves will not have been in the situation that the witnesses are testifying to. But you all can make inferences based on a set of facts presented to you, even though you did not see it yourself, to make a determination as to what happened. And so examples of that in this particular case, you have direct evidence. You have direct evidence of the shooting, at least what the ring camera was able to capture. And as the last set of shots are being fired, you see the victim receiving the impact of those gunshots. And in his hands, it's not a gun. In that video, you see the door closed. That's all direct evidence in this particular case of the victim being unarmed next to a closed door while he's being shot. Circumstantial evidence in this case, an example of which would be Ms. Stuckey being right by the door as she's being shot, or as the defendant is shooting. Now, she didn't specifically say that on the stand, right? But what she did say, what she was able to recall from the stand, as well as the statements that she provided to Detective Berry, was as soon as she closed the door, shots went off. Which would stand to reason that based on that data point, you can infer that she's right by the door as the shots are going off. So right after she closes the door, shots go off. In addition to that, you could also hear her say, I could feel the bullets going past me. Well, that's all circumstantial evidence of the fact that she was right by the door and the defendant was positioned behind her as he was shooting in the direction of the door, ultimately killing Mr. Blunt in this case. Even though Ms. Stuckey is not able to specifically recall where she was at the point in time where her shots went off, what she said and the actions that she described are all circumstantial evidence of where her position was in relation to the door and in relation to the defendant as he was shooting. And so the evidence that you have before you throughout the course of your deliberation is going to be, of course, the witnesses, the testimony and credibility thereof, the exhibits, so like the photographs that we presented to you, the physical evidence that we submitted, and of course the video that we presented to you throughout the course of the trial for you to observe multiple times, as well as the defendant's statements, which are very important in this particular case, because the defendant did in fact make statements to Detective Berry on that morning when she, well, I guess Ms. Stuckey called him and Detective Berry interjected. These are some of the statements the defendant made. He's a kid. I'm a grown-ass man. He checked me. Talking loud doesn't give him the right to check me. And he was going out the door as I was shooting. He was going out the door as I was shooting. Those are all statements for you to consider as to whether or not the defendant acted with the intent, which we'll describe, which I will explain to you, to commit the 4 charges that we have accused of. And this is important, credibility of the witness. That is going to be something for you to determine as it relates to the credibility of each and every witness that the state has presented to you. And everything that Ms. Scott said on the stand was corroborated by Ms. Stuckey later on when you heard her interview with Detective Barrett. Even the small details, seeing the mom come down with a dog, taking the dog out, having the conversation in front of the victim when she got down from the car. Little things like that were corroborated as Ms. Scott was testifying. She's not a biased witness. She's simply telling you what she observed and how she remembered it. And so you look at the manner in which they testify, their interest or lack of interest, which is really important in this particular case, because it may be argued that Ms. Stuckey is biased, or she doesn't really remember everything properly. I'm sorry, if I said Ms. Stuckey, I meant to say Ms. Scott. And obviously, she got visibly emotional at some point in time throughout the course of the testimony. But I submit to you, ladies and gentlemen, that everything that she said, you can take to the bank, because no one's going to sit in this chair, have the 14 of you look at them and recount what is, I only can imagine, being one of the worst moments in her life. Everything that she said was said because she observed it, and because now she's able to recount it to you, which is that she heard arguments in the apartment as she arrived on location with her boyfriend, Mr. Blunt, and her daughter, and that she went up the stairs, thought that this wasn't an environment that she wanted to leave her daughter in that particular night, came back down the stairs, and when she came back down the stairs, her mom followed her, and when her mom followed her, there was a discussion about the defendant and whether you felt safe, and ultimately Ms. Scott said she did not feel safe, but she would go up there and check and observe the defendant point his finger at Ms. Stuckey and call her an MFer. And at that point in time, she said she had enough. So she went back down, and Mr. Blunt, having heard all of the conversations that took place between Ms. Stuckey and Ms. Scott, said, "I'm gonna walk you up there." And he walks him up, or he walks her up there. These are all things that she is able to recount, not because she's making it up, because this is what she observed. And she texts the victim, "Hey, you good? Everything okay?" And then goes up. And as she goes up, she sees the victim outside at the door. Ms. Stuckey is right in the inside by the door. And these are things that she observed. And these are how you can set the scene for how you can explain what the defendant's actions are, whether he acted in self-defense or whether he acted with the intent to commit the 4 charges that we have accused him of. Those are the things that you get to determine credibility of the witness. And based on things that you observed, because you actually had a chance to observe the incident, perhaps the tail end of it, but you had a chance to observe it. You saw the victim. The victim wasn't shooting back. He was just getting shot at. And so the testimony of a single witness, if believed, is sufficient for you to establish a particular fact. And I would submit to you that it would be both Ms. Stuckey's testimony, both on the stand, as well as in her statement to Detective Barry, in addition to Ms. Scott's testimony, that you'll have before you that are crucial in order for you to make your determination to state the court is guilty on all counts. Now, as we talk about those specific counts, in this particular case, as we talk about the counts in this particular case, again, there's 4 counts: murder, felony murder, aggravated assault, possession of a firearm by a convicted felon. And possession of a firearm by during the commission of theft. These are the things that you're going to have to make a determination as to whether or not the defendant acted with the intent to commit the particular acts. And the intent may be inferred from the circumstances of which you've heard from, of course, of witness testimony, from the acts of conduct that you were able to observe from the video, as well as what was relayed to you for the people who were actually there. And, when it's a natural and necessary consequence of the act. So when you're shooting in the direction of someone through a closed door, it's natural to presume that what you're about to do is going to cause bodily harm, in this particular case, death on another individual. And so it's not the intent to violate the law, it's the intent to commit the act. And this specific act that is in question is the defendant pulling the trigger 8 times in the direction of a closed door, intending to hit the victim, Mr. Blunt. So the charges in this particular case, malice murder, it's legally defined as unlawfully and with malice aforethought, causing the death of another human being, which in this particular case is Mr. Blunt. And it's by doing so by shooting. And so what is malice? Well, again, what it's not is the ill will or hatred. So the defendant doesn't have to wake up that particular day saying, I hate Mr. Blunt, I can't wait to get rid of him. It's not intending to sort of premeditate harm on another individual. It's just really the unlawful intention to kill in a particular moment when you are shooting at someone 8 times. And it can be express or implied. And there's sort of a legal definition as it relates to both, which I'll read to you. Express malice is defined as the deliberate intention to unlawfully take away the life of another human being, shown by external circumstances capable of it. Implied malice is legally defined as when no considerable provocation appears and when all the circumstances of the killing show an abandoned and malignant crime. I, as an experienced veteran homicide prosecutor, sometimes have difficulty understanding the legalese behind it. So how I've learned to convey that both to myself as well as to jurors is on this next slide. Express malice is when your actions are deliberate. It's when you make an intention to act a certain way. And in this particular case, we have that when the defendant shoots at a closed door, knowing that people are out there, because Mustafi has just closed the door, he's able to observe all of this, and shoots 8 times in the direction of a closed door, knowing full well that there are human beings on the other side of the door. What other reason would he be shooting 8 times? And it's the intentional act of pulling out that gun and shooting that many times when no one is shooting at you, no one is threatening you in that particular moment. As Ms. Stuckey indicated on the stand, as well as in her statement to Detective Berry, she had no idea why the defendant did it. She did not think that the victim was coming back. In fact, the victim did not knock on the door. The victim was not making threats at the time that she led him away to the door and closed the door. That's all indicators for you and factors for you to take into consideration in determining whether or not malice exists in this particular case. And the state's argument would be, based on the factors and evidence presented in this case, the defendant acted with malice requisite to convict him of malice murder. Implied malice is just when you were able to infer from someone's actions that there is a willingness to hurt someone. So when you close the door as you are leading someone out, and then the defendant shoots in the direction of where that person would be as you close the door, through that closed door, that's all indicators of implied malice as well. Because what other implication can you draw from that? As the door is immediately closed, as Ms. Stuckey is leading the victim outside to the hallway. What other implication can you draw from that? Not in addition to that, it's not just Mr. Blunt that was hurt and obviously killed in this case. It was Ms. Scott who was hurt. And it could have been the neighbor across from their particular apartment that could have gotten hurt. Because as you saw evidence of, there was projectiles in his apartment. And that's all indicators of wanton and recklessly acting without any sort of thought to causing harm. In fact, acting with an abandoned and malignant heart. And as I indicated, malice, it's not something where the defendant has to wake up and come up with a plan to kill Mr. Blunt. Can be formed in that particular incident as he's discharging his firearm 8 times. And motive is not something that the state is ever required to prove as to why someone acted a certain way. But it's certainly something that's helpful nonetheless. And in this particular case, the defendant himself told you, the victim checked. He was a little boy. The defendant's a grown man. And the little boy checked a grown man. And as a result of that, the defendant pulled his firearm as the victim was walking away, as he was being let out. It was in fact outside of the apartment when the defendant fired 8 times through a closed door. And then telling people that he shot, that he meant to shoot. He may have had his reasons that he tells people, but he knows exactly what he did. And he knew it at the time that he opened fire 8 times through a closed door, what he was trying to do, which was to take the life of Mr. Blunt for checking. You're going to hear a charge that's not on the indictment. It's voluntary manslaughter. It's a lesser included charge of murder, and it's going to be for your consideration. The state's going to stand here right now. I'm sure Mr. Badia will as well tell you that the defendant is not guilty of voluntary manslaughter. He's guilty of murder. But that voluntary manslaughter is going to be something for your consideration. And in fact, in order to do your job in accordance with the law, you first have to consider whether or not you find the defendant has in fact committed voluntary manslaughter. And so you'll have a verdict form, and you'll have the opportunity on count 1 to determine first whether or not you believe the defendant is guilty or not of voluntary manslaughter. We're asking that you leave that blank, because the next prompt that you're going to have is how do you find the defendant guilty on count 1, malice murder? And that is the box that we ask that you check guilty. Because that is what the defendant is guilty of, murder, not voluntary manslaughter. Because voluntary manslaughter requires these 4 things. It's causing the death of another individual under the circumstances that would otherwise be murder. But doing so under serious provocation that a reasonable person would not be able to overcome in that particular moment. And that serious provocation was sufficient to understand why the individual acted the way he did. Now, the reason why that doesn't apply in this particular case is this charge is typically used for individuals. A common example is the cheating spouse. Is you walk into your bedroom and you find that your spouse is cheating on you with another individual. In that particular moment, because you have access to a firearm, because what you were seeing is so provocative that in that particular moment, you're not able to be reasonable in that situation. And if you have that thought of wanting to use that firearm and you use it, that is murder. But under the circumstance of which you find yourself, under the context of the facts presented to you, a reasonable person may not have the ability to overcome the impulsive thought. No. That's not what we have here. Because in this particular case, you have testimony from Ms. Stuckey and Ms. Scott that the victim was leaving residence. And certainly there's testimony that the victim walked Ms. Stuckey up the stairs into the apartment, encountered the defendant. The defendant extended his arm and he pushed it away. And the state's not even going to state concede that the victim did in fact have a firearm and that he did in fact show it to the defendant in this particular case. There's no evidence that he had it in his hand, that he pointed it at the defendant, or that he threatened to kill the defendant. Simply showing him the firearm is not sufficient provocation for him to act in a manner in accordance with voluntary manslaughter. for a number of reasons. Because after showing the firearm, we have evidence and testimony from Ms. Stuckey saying that after the encounter between the two of them, she's escorting him out. He is going away. And he knows exactly who he is. They may not have had formal encounters before, but he knew exactly who he was. He knew that that was Miss Scott's boyfriend. They had met a couple of times. And even though they're meeting in passing, it's not like random strangers coming into the apartment. He's being let in by Miss Stuckey. So it's not just some stranger that's coming up here to do it. It's Miss Scott's boyfriend. And as he's being led away, there's a sufficient cooling off period where the defendant has, even if he was sufficiently provoked in that particular case, which I would argue still is not sufficient provocation in that particular moment. Even if he did have sufficient provocation in that moment, the victim is being led away. The victim is agreeing to go away. And the victim, in fact, gets out of the apartment and is talking to himself. Then is being led away to go down the stairs. And as he is turned away, as you heard Dr. Sullivan's testimony, the victim's body's position was consistent with the door facing this way and him positioned this way, which would mean that he is walking and his body is positioned in the direction towards the stairs. Because you saw the gunshot wound to his head. It went straight from his head, through his neck, and through his shoulder. And the only way that the projectile could have traveled in that particular way is if the victim's body was positioned this way in relation to the barrel being pointed at. He is walking away. There is a cooling off period between the time that the victim brandishes his weapon, shows it to the defendant, and him being led away by Ms. Stuckey and being escorted out of it, such that there's no need for the defendant to fire his firearm, to get his firearm and fire it 8 times through the door. But that's not sufficient provocation at that particular time. Even if it was, that's sufficient provocation. Having a cooling off period between the time that the victim showed his gun and left the house or apartment. So it's not voluntary manslaughter, and I would ask that you ignore that and go to the record. Consider it for as much time as you need to, but understand the facts as applicable to the law of voluntary manslaughter, not applicable to this particular case. That this is in fact murder. Now you also have a second count of murder. It's classified as felony. It's different from malice murder because the component of malice is not incorporated in this particular charge. All that we are required to prove is that the defendant committed a felony, and as a result of that felony, caused the death of another individual. In this particular case, the predicate felony in this particular case is aggravated assault with a deadly weapon. It's not the intent to cause the death of another. It's simply the intent to commit the underlying felony act that he's charged with. So in count 2, it'll be felony murder predicated under aggravated assault with a deadly weapon. And if you find the defendant is guilty of aggravated assault, and you have Mr. Blunt, who is no longer with us and has died as a result of being shot twice, then you also have felony murder, and he's guilty of felony murder. Aggravated assault in this particular case is defined as an assault with a deadly weapon, which the judge will also tell you that a firearm, as a matter of law, is classified as a deadly weapon for your consideration. Shot Mr. Blunt, and we're not required to prove actual injury in this particular case. When you all have seen the autopsy photographs, of course, Mr. Blunt is no longer with us. We have an actual injury in this particular case, but that's not really required to prove the charge of aggravated assault. It's simply committing an assault with a firearm by shooting at someone, which we have ample evidence. Now, possession of a firearm during the commission of felonies, basically just having a firearm as you're committing a felony. And in this particular case, we've charged the defendant with 3 separate felonies: murder, felony murder predicated on aggravated assault, and aggravated assault. And if you find that he is guilty of one of those, any one of those felonies, he's guilty of possession of a firearm during the commission of the felony. Now we get to some of the meat of the matter in this particular case. This is the legal principles that you have to go back there with you. One of them being self-defense. It's the state's position based on the evidence and testimony presented to you throughout the course of this trial that this is not an act of self-defense. This was an act of aggression. But this is the law that you'll have to take back there with you. And so we'll talk about it for a little bit. Justification. So an individual is justified in using deadly force if they reasonably believe that such force is necessary in order to prevent their own death or bodily harm, or death and full bodily harm of another individual. In this particular case, the state has the burden of proving that the defendant did not act in accordance with laws of self-defense in this particular case. And you have some evidence of that through Ms. Stuckey's testimony, that the defendant didn't have to do that. She tells him in his own words. And as someone who was in that scene, in that scenario with the defendant, told him, you did not have to do that. Says that the victim was going away. She's leading him out. And the victim was not knocking on the door trying to gain me entry. He was not making threats. He was walking away. And based on that, ladies and gentlemen, that's not an act of self-defense. There's nothing that the victim was doing in the moment that he's walking away with the door closed, such that there's a reasonable belief that the defendant would have had that he had to shoot the door 8 times in order to prevent Mr. Blunt from gaining entry, or prevent Mr. Blunt from shooting at him. Because one, Mr. Blunt wasn't shooting at him. There's no evidence of that. In fact, there's every piece of evidence points to the defendant being the shooter, because there's 8 defects through the door. There's 8 shell casings in the apartment. And all those shell casings go back to the gun that the defendant hid behind the couch. No other evidence, both from what we see on that video or otherwise, to indicate that the victim had a gun in his hand. The victim threatened the defendant when he was outside behind the closed door. No evidence to indicate that the defendant was acting in self-defense, such that he needed to shoot 8 times in order to prevent himself or Ms. Stuckey, who the victim was there to protect, from death or great bodily. In addition to justification, there are also legal principles as it relates to defensive habitation. Whenever we all have the right to defend our own homes. I think there's a little bit of a issue of whether or not the defendant actually was living there, based on the Stuckey's statement to Ms. Berry. I know she testified otherwise on the stand, and I understand the precarious position she's in, because on the one hand, you have someone that you've been in a relationship with for 7 to 8 years, the defendant, and you have someone who you care for, who your daughter cared for, who's deceased. And I can understand why she testified in the manner that she did before you all, ladies and gentlemen. She's a little bit torn, and I can understand that, because it is a very complex situation for her to be in. I'm sure it's a whole bunch of emotions for her to be in this situation. Her specifically, given that the defendant shot and killed her daughter's boyfriend, and of course, her daughter's boyfriend, Mr. Blunt, was someone that she was not a stranger to, for lack of a better phrase. The victim, looked up to her as his own mother, and he wanted to protect her as his last act on this earth of escorting her up the steps. So, defensive habitation. The defendant is justified in using force against another individual if they're preventing death or serious bodily injury. If the act itself is intended to prevent that scenario. In this particular case, it's really applied to people like home invaders who come in and want to take what isn't theirs and have no invitation or reason to be. In this particular case, Ms. Stuckey at least allowed him to walk in. And the defendant knows he's not a complete stranger because at least he's seen him twice in the past. And knows that he's Ms. Scott's boyfriend. In fact, he says to Detective Berry, they called him there. So he knows that he is related to them in some way, shape, or form. So he is there and he brandishes his firearm. What I suspect is a moment of him recklessly and foolishly and perhaps immaturely trying to let the defendant know you're on notice. Don't do that again, because they can hear the arguments. And ultimately leaves the apartment. And there's no evidence that he's trying to gain entry back into the apartment such that the defendant in that moment has to shoot at the door 8 times to prevent Mr. Blunt from getting in. In fact, you see on the video, he's not trying to get in, he's just getting shot at that particular moment. So the laws of habitation and defense of habitation don't really apply in this particular case because there's no reason the defendant had to discharge his firearm 8 times in the direction of Mr. Blunt through that closed door in order to prevent him from gaining entry. He was leaving, and not only that, but Ms. Stuckey said he wasn't knocking on the door, wasn't making any threats. So there's no reason for the defendant to act in the manner that he did that ultimately led to Mr. Blunt's death. And so reasonable beliefs, just like reasonable doubt, has to be reasonable. What would a reasonable person in that situation do? And so there's 3 things to take into account in determining whether or not the individual is acting reasonably, which is what the defense is asking you to consider in this particular case, by shooting through closed door 8 times in the direction of the door. You must believe that the threat or use of force is necessary in that particular moment. That a reasonable person in the defendant's position would have believed that the threat or use of force was reasonable in that particular instance. And that reasonable belief of the defendant causing death or bodily harm upon himself was so reasonable that the only act that the defendant could have done to protect himself was shooting through the closed door 8 times in the direction of the door. And every piece of evidence that's been presented through the defendant's own statements, through Ms. Stuckey's statements on the stand, as well as Detective Berry, as well as Ms. Scott's testimony throughout the course of this trial, all are what you can draw upon to show that that was not reasonable in this particular case, that he did not have to shoot 8 times through a closed door that ultimately led to the loss of life of Mr. Blunt. Not once.
Objection.
Is there something on the screen that you're objecting to? Okay, yeah, why don't we skip this slide and move on? Okay.
You heard what you heard from the defendant's statement to Investigator Berry. All he said was, "You check. I'm a grown man. He's a kid. He checked." And he tries to spin it as, yeah, he pointed the gun, even though no testimony from anyone else who was actually there says that he pointed the gun at the defendant, that he threatened the defendant with death. You can hear from Ms. Stuckey saying, you didn't have to do that. She's in that situation right there as it's happening. It is able to make the determinations that the victim is leaving, that he's going away. But it's just not a huge apartment. The defendant's right there. And he sees what's going on. Because he himself says in his statement to Detective Berry, "I shot him as he was walking out the door." He himself is admitting that the victim is leaving. Mr. Blunt made no intention of re-entering the house. We know that from his study statement and testimony. And as I indicated, he's shooting him as he's leaving, as he's going out the door. There's no reason for self-defense in that particular moment. There's no evidence that the victim had a gun in his hand as he was leaving. In fact, there's all the evidence to the contrary. Through the video, as well as Ms. Scott's testimony saying that she took the gun from the waist. The defendant told you why he did it. It wasn't because the victim had a gun. It was because he was being checked. And in his mind, as he specifically says to Detective Berry, I don't know what other relevance it would have for him to say that. I'm a grown-ass man and he's a kid. He checked. So in his mind, he's thinking, I'm the adult, you're the kid, you don't get to act like that in front of me, I'm going to show you. And then leaves after he shoots and kills this kid. The kid that he describes as a kid in his own words. These are all the statements that he made to support that. He came in there to check. He's a kid, but I'm a grown man. They called him over to check. He came out trying to check me. He just came into the house trying to check me. I'm a grown-ass man. That doesn't give him the reason to come in the house and check me. I'm a grown-ass man. Why would a little bitty ass boy come in and try to devo? That doesn't give him the right to come in and try to check. He came in there to try and check. He's so obsessed with this kid coming into the house to check him that he shoots through a closed door 8 times to assert his, I guess, manliness. Which is, interestingly enough, what Detective Berry said to the defendant before he hung up, or that call in. Sounds like he was calling into question your man. Because he was checked by Detective Berry. Because it wasn't really adding up. As soon as she mentioned that, no. And then he ends up in Ohio. Shooting through a closed door. Shooting at anyone, even if closed door or not, 8 times. No one is shooting at. When there's no threats and no reasonable belief that you are in harm in that particular moment, it's excessive force. The defendant intended to shoot Mr. Blunt 8 times. For whatever reason, Mr. Blunt was only shot twice. But the defendant meant for him to be shot 8 times. Any one of those bullets, as Dr. Sullivan testified, was enough to kill him. But the defendant shot at him not once, not twice, but 8 times. That is excessive force. Because when no one is shooting at you, no one is making threats to shoot at you, because there's no evidence of that. That is excessive force. And it goes beyond what any individual in that scenario would reasonably believe was necessary in order to protect yourself or your home. Which, I don't even know if that's really his home. It doesn't sound like it was. It doesn't sound like Miss Stuckey wanted to keep him along. That's her boyfriend. After May 1st, when the lease was up. Which his name wasn't on. Excessive force. You can't shoot someone for simply brandishing the fire. Or displaying the fire. And yet, you saw Detective Berry kind of show Miss Stuckey, like how was the victim handling his firearm? And she kind of does this motion. Like, is it consistent with this? And Miss Stuckey agrees. Victim never actually took the firearm out to point it at the defendant. There's no evidence of that. Stuckey doesn't say it. at the time of her statement to Detective Berry, nor did she say it on the stand. You can't shoot someone for check. So if you feel like this kid is being disrespectful to you, the way to handle that isn't by you taking a gun and shooting at him 8 times. And you certainly can't do it when the door is closed. Because at that point in time, you are conceding you have no idea what's going on. You don't know what the victim is doing. And we have every piece of evidence to show us that he was walking away. Nor did Miss Stuckey say he was knocking on the door, was making threats. He was being escorted out, the door was closed, the victim did not try to force himself in, yet the defendant shot 8 times. It's excessive and it's unreasonable. That's why self-defense doesn't apply in this particular case. Eight shots at someone who's leaving. 8 shots at someone who you thought was a kid, in his own words, without any regard for who was actually outside the door with him. And in this particular case, I mean, the defendant is telling you why he did it. And you'll have this law in consideration, revenge for a prior wrong. He was checked, and he did not like it. It may be a dumb reason to kill somebody, but I think we've all been exposed to the news as of late. We've really seen how people act with disputes when they have access to a gun. And so it may not make sense to us on this side of the courtroom, but that's unfortunately what happened. It is something as stupid as being checked that resulted in the victim's life being taken away from him. And so no matter what provocation the defendant had at the time that the victim displayed his gun, we know that the gun was in the victim's waistband, certainly not in his hands as he was being shot at. That the defendant did this because he was checked. And that this is in fact really revenge for a prior wrong, which is the law that you'll have there for your consideration. And a person is not justified in acting revenge regardless of how bad the provocation was prior to the incident. And you're acting solely in revenge. And you know, based on the facts and evidence presented to you throughout the course of this trial, there was no reason for the defendant to shoot 8 times through a closed door as the victim was walking away. This is an act of aggression. This is not self-defense. This is a result of someone who did not want to be disrespected by a child. This is someone who made an intentional act of retrieving a firearm, waiting for the door to close, and shooting at Mr. Blunt 8 times through the closed door. And as Detective Berry put it perfectly on the conclusion of her phone call with the defendant, it sounds like your manhood was called into question. How convenient that the call ends there and the defendant is later arrested in Ohio. It's because he knows that Detective Berry was right. And that he's guilty of all the charges in this indictment. Thank you, please.
Thank you, Mr. Rao. Ms. Rivers, you good? You want to take a quick break? Just to log back in? Okay, so you're going to stay right here. All right, Ms. Feely, if you want to switch things over, Zoom has again rejected poor Ms. Rivers. She's going to log back in. doing its usual thing? Okay, sorry about that. It's on my list to talk about with IT.
Okay.
All right, Ms. Feely, are you ready?
Yes.
Great. Ladies and gentlemen, this is the defendant's presentation.
Like I told you, unknown, unpredictable, armed with a deadly weapon. I don't know why the state is trying to downplay this. This is not a check on something. This is a threat. They can say it as many times as they want to. They can make fun of Mr. Hall all they want, but this man walked into this room. Wasn't about masculine. 3 major case felony prosecutors, all the investigators, all the resources of the DA's office cannot change the fact that Mr. Blunt is the aggressor. And one of you, or maybe more than one of you, actually asked about self-defense during the trial before we talk about it, because that's what this is. If you can get Mr. Hall of these charges of murder when somebody paid in his act, and I would say this many times too, he was sitting in his living room, watching TV. This man came into his house. Self-defense applies just as much to someone who lives in Blunt as someone who lives in Blunt area. And convicting you of murder says it only applies to certain. And we all see the same headline, we all live in the same town. And very recent, and over and over and over again, you see Buckhead man kills intruder. They don't even talk about whether that intruder was armed, because he had every right to kill that person. This is not murder. This is not felony. This is not aggravated assault. He was not committing a felony, so he can't be guilty of possessing a firearm while doing so. This was as cut and dry self-defense. He didn't know him. The state, I am so happy that I saw you all take it. Because what I say is evidence, but what they said is not evidence either, and I expect it's gonna get worse. So you have to be the gatekeeper. Just because the state puts it on spot doesn't mean that's the witness said. You heard what you heard from that. They can mischaracterize videos, they can put words in people's mouths, but you heard. And if you want to watch again, just ask. There's any piece of evidence you need to get in. And it's that important that if you do, please ask. Let's say, this is my only issue, so I can talk about the law as well. So I wanted to point out, the state gave you a little analogy about the gas station. That's cute, right? My client's charged with murder, but sure, a gas station. I don't care how much gas you put in the car. If the tires are flat, it's not going. But that's what we have. If the tires have holes in them, like the state's case, you can't patch those when the evidence is closed. And you can't tell what the government's trying to hide by just saying things. Manhood, buzzwords, playing music video, which I warned you about. All of that, the prosecutors often accuse the defense of smoking mirrors, but they just spent a whole trial trying to convince you of something with all this additional stuff. They brought an extra witness today who wasn't even involved in this case. You cannot patch the holes. Not by speculation, and not by sympathy.
not by anything else. You have got to make sure the evidence that was presented. Now, I need to talk about this in 2 days. Detective Barry mentioned probable cause to me. So that's down here. That's probable cause for an arrest. That's just to arrest someone. Much lower. We're up here. And there's no way I can overstate how high the burden is. And it's good. This case is very important. So the government must not only prove beyond a reasonable doubt, even though they didn't fingerprint it, that Mr. Hall fired the shots. Even though the only other person in there was his girlfriend of 6 years. Who maybe had reason to check. She's the one who's in the police station giving the statement. We would know that if fingerprints had been done, which could have been done last week. I mean, this is probably not now to handle, but that's not a test that there's a limitation in general if fingerprints are done. But not only does the state have to prove to you beyond a reasonable doubt that Mr. Hall fired the shots, they have to prove beyond a reasonable doubt that it was not self-defense. I know that sounds like a kind of double negative or something like that, because it is confusing, but we've raised the affirmative defense of self-defense, and the state has to disprove it beyond a reasonable doubt, and they cannot, and they didn't. Because that's exactly what this was. You heard, the state doesn't have to prove motive. Look what in the world would motive be? You heard Mr. Hall and Mr. Blunt weren't friends, weren't enemies, weren't beefing. Why would he shoot him if not to? Because he felt in danger and he was in danger. There is no reason, and the state doesn't have to prove one of it. It doesn't make any sense anymore. The state had their opinion about what was said in the video that you heard there, always on the phone call. But you can hear the fear in his voice, and how upset he is, and how he says, I didn't intend this to happen. Because he was sitting on his couch watching television. He didn't intend for this to happen. He didn't intend for this man to come run up on him and pull a weapon in his house. And so please, rely on remembering your notes or listen to it again. But this stuff he says, Jason was scared. Jason got scared and pulled out a gun and screamed. He was afraid. Of course he was. And the state tries to act like this is like minutes and but this happened extremely quickly. This whole scenario. There wouldn't have been a cooling off period because there was nothing to cool off from. He just approached him and threatened him. And say he was leaving, he was walking out. No, he was being shoved out the door on his stomach. And he was still, we don't know because of the video that the state has. In the 2022 when this happened, that's the ring cam that we got. If you, like I told you, you wish you could see the demeanor, everything that happened. When Mr. Blunt goes in the apartment and how he comes out, that is reasonable doubt. That is doubtful which a reason we just. So the way this burden of proof stuff works in terms of where we are here. So the first one, that Mr. Hall was the one who fired the shots, must be proven. Not he probably was the one to do it, or he maybe was the one to do it, or even you're gravely suspicious that it's. That is not proof beyond a reasonable doubt. If you have those doubts. Now the way this applies to self-defense is if you think possibly he was acting in self-defense, that's not good. So it is confusing, but if you believe possibly he was acting in self-defense, And I think there's more than that, but that is enough to be a reasonable doubt. And you would have to, but if you believe it probably wasn't self-defense, it's not here. If you saw the same evidence I did and you believe that he probably wasn't acting self-defense, that is reasonable doubt not guilty. You have to be convinced beyond a reasonable doubt that when Mr. Hall fired those shots, it was not his self-defense. And same thing, even if you are gravely suspicious that Mr. Hall wasn't acting in self-defense, that is not enough. You have to be convinced beyond a reasonable doubt that he was not acting in self-defense, because he was. Another thing that I want to point out about the self-defense, issue of the law of self-defense. But it's not about what Ms. Stuckey said, or what Ms. Stuckey felt, or what anybody else felt. It's about what Mr. Hall reasonably believed. It's not whether you wish he had done something differently, or you think in his position you might have done something. It is what he reasonably believed. And what else do you reasonably believe when somebody comes in your house and pulls a gun? You heard Mr. Hall sitting on the couch, he stands up, still not being aggressive, still not starting. What else was he supposed to reasonably believe? So when you're back there, Monday morning quarterbacking, maybe he did too much, just remember, it's not about now when we're looking back. It is about what he believed. And the quickness that happened, unpredictable, is super important because he doesn't know this guy. But he knows he's got a gun with a magazine. I can't remember, they said 8 or 12 rounds or something like that. He wasn't coming in here to play around. You cannot convict a man for murder when he was sitting in his house. And this happened in moments. But the government is making people like you not caring about who live in the world. They made a big point out of who didn't have you, so they take the guilt. As long as we have had laws, going way, way back. Self-defense has always been. Man's house is his castle. Even king can't enter. It's always been a key. For just this reason, that's why the headlines are there. The circumstances as they appeared at the time were not created by Mr. Hall. The circumstances as they appeared at the time were created by Mr. Preston. The state also makes a really big deal about the fact that after Ms. Stuckey shoves him out the door, she did manage to shove him. But that didn't end the threat. It didn't. We know that because, as I said, if shots can come out, shots can go in. And again, we live in the same town, we see the same headlines. You do see that a lot, where somebody goes in and shoots a house up, apartment up. And he could have walked right back in. Unpredictable to Mr. Hall. But the threat was not he was not leaving. He was being forced out. He wasn't invited in to start with. Ms. Stuckey was trying to de-escalate the violent situation Mr. Hall caused. He was still on the landing. The last time Mr. Hall saw him, he did have a gun. Whether or not you think the video shows he did or didn't. The last time Mr. Hall saw him seconds before, he had a gun in his hand. That gun. That wasn't tested. Talk about that too. No duty to retreat. He was in his house. You heard from everybody how small this place is. Tiny apartment. Comes in. The state wants you to believe that this was just all plugged together and that there was a break in the action somehow. No, this was an ongoing threat that Mr. Hall in his home did not have a duty to retreat. That applies to everyone's equally. We're gone. The stand your ground law applies to Mr. Hall. Let's talk about Ms. Stuckey. The state again claims without very much evidence at all that Ms. Stuckey was super close to Mr. Blunt. Ms. Stuckey told you under oath she met him a couple times. But to hear the state argue it, that was her son. But that's just not true. So please rely on your memory, not the state's. But it also did sound like she was the one who kind of either Mr. Hall or walk her dog or off. But she did say, tell Detective Barry, that Mr. Blunt pulling the gun is what's chasing. Which may not be the word that we use necessarily, but she also said scared. She also said afraid. The state argued to you straight faced that Ms. Scott's testimony was completely weird. Was everything she said was corroborated. That is not true. She testified that she and Ms. Stuckey went up there together before Mr. Blunt went up there. Ms. Stuckey did not remember that. She came up with this where to make Mr. Hall look bad that he used profanity at Ms. Stuckey. Nobody else confirmed that. That is not corroborated. But what's interesting is that after Ms. Stuckey testified, the state was really quick to play a prior statement. Did you catch that? But Ms. Berry also told you that Ms. Scott gave not one but 2 prior statements. The state didn't play those. One of them was in my head.
I'm gonna object to the state couldn't legally play those based on the evidence laws here in the state of Georgia that we were all to apply and consider as we try.
Okay, well, I'll just note this, that both sides have the ability to play videos. This is discovery that was available for both sides. And so if there were inconsistencies in a video, it's not that only the state could have played any statements that Ms. Scott gave to law enforcement. Both sides have the ability to do that.
So let's talk about the missing and tampered with and tainted crime scene. Missing evidence. They can try and justify it all you want. But it's their burden. This is all of the evidence in a murder case that they have. And the state can try to downplay, minimize that the gun was moved. That is not okay. Detective Barry tried to act like we were that. You saw how meticulous, because the mistake is she's on her game, she's good at her job. And you saw how she took a picture from far away, she took a picture from close, she put a marker by it, she took a picture before she touched it. And had the gun been there, and you heard it was Ms. Scott's gun. Had the gun been there, we would know where it was. And I confirmed with Detective Barry, you don't get another chance in the investigation. Somebody moved the gun,
And now the 14 of you will never know where that gun was. It is the answer. The next one, where was it? That evidence was destroyed on the spot. Talked about this a little bit. This is another jury charge. This is another example of what is not reasonable doubt, what is not beyond a reasonable doubt. You're greatly suspicious that Mr. Hall was not firing self-defense, but for some other reason, but that he was checked. That doesn't even make any sense at all. But if you think that it was for a reason other than self-defense, you're greatly suspicious he shot for a reason other than self-defense. That is a doubt of the law. Nobody is happy to be here. I alluded to that a little bit. But what Mr. Hall reasonably believed was that he was in danger of receiving a violent bodily injury, he had a gun to line. Mr. Hall couldn't have predicted this when he was sitting in his living room. And he was justified in the steps that he took to defend himself in his home. State nitpicks that too. So this is the state's favorite jury charge. They've already talked about some. The testimony of a single witness is sufficient. This does not read the testimony of a single witness proves the case. The state tries to act like that's what it says, but that's not. It is the testimony of a single witness, if believed by you, is sufficient to establish a fact. If you find it to be sufficient, then you don't have to. Let's talk about Miss Scott claimed she heard glass breaking. Remember that? She made it a big deal. Glass breaking. CSI Davis, if there was evidence of broken glass, would have taken a picture. That's evidence of something. You heard them say you may not know what exactly they're here for, but anything possibly evidential. She would have taken pictures of broken glass. And you don't have to get into Scott's head and try to figure out why she's saying the things she's saying. Because some of them are just verifiably untrue. The state has to prove beyond a reasonable doubt that Mr. Hall intended for this to happen. They can't make it. The judge is going to instruct you on what the state was talking about. Revenge. What? Revenge for what? You're going to get a revenge jury charge. Revenge for you are not friends, they're not enemies, they're not people. There's no revenge. And it, again, the state mischaracterized an attack on his man, but that's not what it was. You came in his house with it. Do not let them confuse you about that or down on that. This is hard. This is not easy. You cannot, it's absolutely, completely, totally reasonable to be heartbroken by this situation. Because it's heartbreaking situation. It's tragic, it's horrible. You can feel sympathy and his family and what they've gone through, and it is perfectly normal and healthy to feel that way. But you cannot base your verdict on it. You cannot. The judge is going to instruct you, and I know it's hard, but you cannot. You took an oath that you would follow the law. This is one of the judge thinking it may be difficult. But you took an oath to do it. But the judge is also going to instruct you that wherever your verdict is, it must be agreed to by all, which is true. But you do not have to agree on your reason for doubting the state's case. So reasons that you should doubt the state's case. The first one I want to talk about is the one that I talked about in the opening, and that is the videos and autopsy photos. The videos, I told you, you'd see, I had the over on 5. I actually lost count. I think maybe a little less than that. We probably will see them in just any opportunity to play them. Like I told you in the movie, because that's hard to watch. It's a difficult thing to see. And state's looking at you will be like, gosh, that's terrible. Guilty, murder, without considering the things. And the state gets to try to prove its case, attempt to prove its case however it wants. It's their burden of proof. But it was their choice to show you all of those autopsy pictures. Leaving them up, distracting with disturbing images. The same videos over and over again. Maybe you may not forget them, they may be traumatizing. You've seen it again probably. And they did that knowing full well that the defense was not, he died. He didn't die from the injury. They knew that. We weren't challenging that that was the cause of it. They showed them all to you anyway. You have to ask yourself why, but I would think you're. So one thing that I wanted to just clear up is Dr. Sullivan, fantastic. Wish she was running the investigation. Her only role was the autopsy, which she knows that she always does. But I wanted to talk with you because she explained to you the cause of death has been talked in the manner that every self-defense that results in death, any self-defense shooting that results in death, the manner of death is always homicide, always. Because it's not accident, suicide, natural, or unintentional. That's the only other category. So she doesn't get to do the police investigation and know what all we know now. So don't get tripped up because the great wonderful Dr. Sullivan said the manner of death is homicide, because that does not exclude that. And there would never be, she would never examine a body with gunshot wounds that weren't self-inflicted and be able to say regardless. She told me. So all the gunshot wounds are on the front and side, with one exiting in the back. And then that is how you prove something not reasonable doubt. The state, I will give them, but the state has proven to you, in my opinion, beyond reasonable doubt, that at least one died from the wounds. That's how you do it. That's the level of proof we're talking about. But every self-defense shooting death case, manner of death is not proof. Another reason to doubt the state's case is what we also talk about in their confirmation instead of investigation. And you heard Detective Barry say from the stand, well, we had our guy. Why would we fingerprint the gun? We got our guy. Why would we collect DNA? Why would we get samples, hair samples, blood samples to confirm anything? This case is a mess. No fingerprints on the gun, no touch DNA, no ballistics, the second firearm at all. The second firearm wasn't tested at all. It's just here in this murder trial, the box, having never been tested. The crime scene, the inconsistent statements are the only witnesses that we have. And another reason for that is Mr. Hall himself. Sitting in his house, not bothering anybody. The state tried to make a big deal about him cutting his hair, changing his hair. And they tried to do it through a witness who had done this. Her hair was much longer in the video than it was, detective hair, than it was on the scene. It's not evidence of guilt. It's not evidence of anything. They also tried to make a big deal that Mr. Hall was arrested in Ohio. But we also heard from several witnesses, including Detective Berry, about what a scene it was at his apartment. She tells Miss Stuckey, I can't take you back right now, but like, you just cool out here for a little while. Because of how volatile it was, people are upset, as is natural. The government wants you to believe he went to Ohio because he was guilty. It really was because of the state. You didn't hear about there being some big manhunt, shootout situation, no trouble at all being transported back to Georgia. You heard from one of the witnesses yesterday, he signed extradition. It also tries to make you think Mr. Hall is like some aggressive. But even though this man, he barely knows, came in his house, it's 10 o'clock at night, barges into his house, he still stands up to shake his hand. Y'all heard that. He stood up still, thinking everything was fine, shaking the man's hand. And got it. So the state also told you in opening that you were going to hear about all these wild, loud arguments that Mr. Hall and stuff you always getting into. That's another example of you remember what the actual was. So they said that that was what the testimony was going to be. That was not. We had the first neighbor gentleman who was part-time dog walker guy. But he's there pretty often, and he said, "Yeah, I heard arguments during the day. It was tuned in." That he's trying to be helpful, but that doesn't have anything to do with this case. That was other people. And then the full-time residents, they've got a ring camera back. Not never said, not that day, not. So the only evidence of that is hearsay from Detective Berry about people because it wasn't the people who testified. Now, no matter how you felt about law enforcement before coming in here, you should be critical and you should be skeptical about Detective Berry and how it's taken, what was not. And what you can't do is hold back against his call. So let's talk about Mr. Hall's phone call with Detective Berry that you heard. He's upset. He's not happy. Does this happen? He says, "I never intended this to happen." You can hear the fear in his voice. He's scared, he's upset. But what he reasonably believed before the shots were fired is what matters. So we already talked about what all evidence were missing. The state search warrant also talked about electronic devices. We don't have any cell phone records, anything like that. All of the forensic evidence we talked about, but even though this is a murder case, was not done. The rest of the videos we talked about,
How about the rest of the 911 call? I saw several of you writing, making a note that it just cuts off. Speaking of just cutting off. I mean, you're guilty if you didn't take a call, but it doesn't matter if it's a 911 call. The 911 caller. A witness. Where is he? Where is the person who called 911? There are other reasons to doubt, and I know that, and I'm going to take notes. The state argued to you that you cannot base your verdict on what is in there. I wrote that down as a mission. You absolutely can base your verdict on that. Now, I'm older than most of you, but when the year I was born was 1982. And that year was the year of a pretty famous recall, Tylenol. Few people died in one region of the country because the Tylenol was laid to the side. All Tylenol across the country were options, all of them. Not because 1 in 5 Tylenol or 1 in 100 Tylenol balls passed out. 1 in a million. They pulled them all because the odds are in your favor if you take some Tylenol right now. But there's no proof beyond reasonable doubt that your body doesn't have something. The doubt that someone could get a sign that is reasonable. That is reasonable. And the risk is death. The consequence is super high. And the doubt that it could be used, that they pull them all. So any questions that you have about what happened on April 30th, 2022, look no further than the government's table. They are asking you to make Mr. Hall a convicted murderer. Based on what just the evidence that you heard. They have to bring evidence, not just argument, evidence to prove beyond a reasonable doubt that Mr. Hall was an So the government gets to go last, first and last. So this is my last opportunity to address you. As soon as I sit down next to Mr. Hall, I'm going to think of probably 50 things I can say. But I know that you took notes and paid attention to this trial, and that you're taking your oath seriously. Do not let the state make you forget what the evidence was and what it was not. Do not let the state try to minimize their burden like they've already tried to do. Not beyond all that. Mr. Hall did what he had to do under circumstances that were not caused by him. And he was reasonable to do so. The state cannot and did not prove it. As tragic as this death is, and it is, this is not murder. I wanted to point out a couple of things. There was evidence that came in as just a stipulation. You'll see my signature. This is not any kind of concession. We are stipulating to comment for the court because of what you've heard about. But we're not admitting that that's all that should have been done. We're not agreeing that fingerprint should have been tested, or we just are simply stipulating to comments back and forth. Do not let the state mischaracterize, which they've already done, what the evidence was. Don't let them put words in people's mouths that were not said, that you didn't hear or see it. Do not let the state try to convince you that Mr. Hall shot because he felt disrespected. That's ridiculous. That's not what happened. And this is more than disrespect. Come in a man's house with this in your waistband and pull it on. He's not leaving voluntarily. He busts in with this gun, this extended magazine, aggressively. There's no other word. That is aggressive. He is the aggressor. The stuff he sees that she separates him and tries to push him. It's an ongoing threat. This is a reasonable belief of suffering an injury, bodily harm. Mr. Hall was justified in doing what he did because that belief was reasonable at the time, knowing what he knew and experiencing what he was experiencing, but he didn't ask for anything. I know this is hard, but do not compound his tragedy by sacrificing the I know his family is here, but you can't decide this case without. You have to use your common sense and reason, as hard as it is. You took an oath to base your verdict on the evidence. That's all I'm asking you to do. But Mr. Hall knew at the time, this is not murder, this is not felony murder. This is self. You'll have all the evidence back there with you, and I urge you to take a careful look at everything you need to take a careful look at. Ask for things that you need to see. And then, as hard as it may be, and as reluctant as you may be to do it, you must return with the only verdict that the evidence supports. And that is that Mr. Hall is not guilty on all counts.
Thank you, Ms. Feely. Excuse me, we're going to take a break before we hear from Mr. Abate with the rebuttal from the state. To manage your expectations, that's what we're going to do for the rest of the day. Not that he's got an hour and a half left. They don't have an hour and a half left. But when he's done, we'll be done for the day, so that when you return tomorrow morning, hopefully at 9, but we'll talk about when you want to be back here tomorrow morning. I'll give you that jury charge, as in I'll read you the law, and then you'll be able to begin your deliberations. But right now, let's break for 10 minutes. Let everyone just shake it out for a little bit. We'll let Ms. Rivers recharge. and then we'll get you back in here. Please don't talk about the case. Not time yet. No outside research. We'll see you in about 10 minutes. Thank you. You're so optimistic with that. Try it again. There's some issue back there. They can't see the YouTube feed on our machines back in chambers, but they can get into the YouTube feed from external devices. Mr. Abate, anything we need to get on the record before we break? Ms. Feely, I would ask you between now and the end of Mr. Abate's closing to think through what piece of defensive habitation you want to get. There's 3 different versions. None fits perfectly because they all involve, well, they don't all involve, 2 of them involve unlawful entry, and I don't think that's the set of facts we've got. So we need to figure out what language, if any, I'll be including from defensive habitation. There are 3 different permutations of it. So take a look at it over the break, and we'll talk about it with Mr. Hiles not waving that door back and forth, and work through that, okay? Thank you.
I have one thing, I guess I'm on the record now, the explanations later. I definitely intend, when talking about the statement of the defendant, to talk about what he said and what the evidence shows he didn't say, which is not coming on the right side. It was a call that actually was Stuckey made to him. It was not a custodial interview. It's a call that he could have hung up at any point. And I don't believe that's commenting on his right side. So I will be mentioning.
Okay, so we just need to be thoughtful in that area. Certainly, you referencing everything he said is 100% okay. And it was not, can we do that in a second and finish this conversation? Thanks. If you want to bang a gong while we're talking too, that would be super. I think you know the guardrails, and so the points you're making ought not to be, and he never ever called law enforcement to say X or Y or Z. I don't think Mr. Rao had gotten that far either. The slide in its static way, I think, got us closer to that area where an inference could be drawn that you all were saying, why didn't he ever tell anyone? But your focus is going to be, here's a chance. He was talking with the detective and with Ms. Stuckey, and here's what he said, and here's what he didn't say. You're welcome to object when that happens. I appreciate you flagging that. I'm not going to preclude you from exploring that. Okay, let's take our break. I'll be back out here in about 8 minutes. Now feel free to move things around.
Is it just play the? This is. Oh.
Thank you.
Where's that you can get up under there? Think so.
That doesn't work.
Oh.
It should be the Wi-Fi.
It's not.
It's on the side. So stand up. I don't have the run to. Plan.
No. You said you had to look. No. You said, I've been doing this myself. You're in the wrong. Do it again. Do it here. You're gonna say, what are you doing? This was it. I did the same. This is what I'm saying. That's what I'm saying. I got to do it. You can go on my day. Don't have trouble. Have trouble. Steps though.
How's the technology working for you?
And so,
Turn it there. Turn it on. The sound.
Every time you turn that sound on, you get the feedback. So you can hear people talking, but you also get that.
Feedback on sound.
to the apartment in the first place. And you said some folks was knocking on the door. What they want?
All right. Once this prints out, I want to get it going. What else here? That. This. So Ms. Feely, you should feel free to relocate if you want to. I don't think this will push through our Zoom system. Are you ready for the jurors? Yes, Ms. Feely, anything?
Couple of things. One, I would like to review my request that this they omit the two places where weed is mentioned, because and presumably they're going to hear a little bit better on this system than they were other, but I did note at least one juror making me look at that's my first time. So that is our vote request to exclude that under as it's improper character and hasn't further value in the trial.
It's something your client says, though, just so I'm remembering correctly. It's not that someone else asked that Barry didn't say, were they there to get weed from you? It's something that your client volunteered.
Right.
Okay.
I don't think that makes it admissible.
I didn't say that. I just want to understand the context.
So we review that to exclude that as improper character evidence. And its prejudicial effect is quite substantial in our opinion, given it has no further value. And then, do you want to discuss the jury charge later?
Yes, jury charge after we send a jury home.
The only other thing is that Mr. Lafayette tends to talk about things my client did not say. I do think that is commenting on his silence. I think as far as he made it go is he only said X. But if he starts saying my client didn't say certain things, I do agree. But just, you're welcome to do whatever you want to, but I have a motion. Goes too far.
Well, let's not go too far. Let's not get emotion. You're certainly able to talk about what he said. And that's all he said. It does start to go down a slippery slope when you say he didn't say. Now, I appreciate this is not a custodial statement. It's still him talking to law enforcement. He knows who he's talking to. So it's different from a jail call between Mr. Hall and Ms. Stuckey, where he says that guy deserved it, or he tried me, or something like that. But we're in a slightly different context because the inference from what you are, or the unspoken part of what you would be highlighting and arguing is he didn't tell the police X. And that's the problem. You're not going to say those words, but because Detective Barry is part of that conversation, it's he didn't tell the police. He had a perfect chance to say this was self-defense to the cops, and he didn't, but he doesn't have to. And it wasn't a conversation just with Miss Stuckey. That's the area about which I'm concerned. And so that's why I'm cautioning you to tread lightly in that area as to how you word what wasn't spoken.
So I understand, I respect your Honor's, suggestions by all means, but commenting on a defendant's right to silence is if they don't make a statement and I indicate to the jury he could have made a statement. I can't comment on somebody's right to silence when they chose not to exercise their right to silence and have a conversation with Ms. Stuckey, the police, whoever. So I think it's more than admissible and allowed under the evidence rules here in the state of Georgia and the United States that I can say during a conversation with whomever, the defendant did not say X, Y, and Z, because that's what the evidence showed. The defendant did not say X, Y, Z.
And I think if you limit it to that and don't extrapolate to, boy, he could have told the police this or that, and why didn't he show up for the next interview? You need to be careful because there is case law that says it's improper to argue to the jury, hey, when the police rolled up on him, he didn't, and they were handcuffing him, he didn't say, wait, what are you doing? I'm the victim here. The failure to say something, as the state might characterize it, is equally so the right not to say anything. You see what I'm saying? I don't mean to be unclear about it, but I'm familiar with case law that finds error and prejudice when a prosecutor argues in closing argument, boy, he had a whole lot of opportunities to tell the police that he wasn't there or it was self-defense, and he didn't do that. He's not under an obligation to do that. And that silence isn't something that can be, he could have taken the stand here. I know you're not going to say that, but what's the difference? He didn't take the stand, and we're not going to talk about that. He didn't call, the phone went dead. His battery died. He didn't charge the phone and call Barry back and say, hey, let me finish my story. I was scared of this guy, and that's why I shot him. He didn't do that, but he has a right to say nothing at all. And so the state is somewhat limited in what it can say about what wasn't said. So I think if you draw to the jury's attention that during that conversation, self-defense didn't come up, Ms. Feely can object, I'll overrule that. And I think that I'm safe in overruling that. But if you spend a lot of time talking about this guy, Mr. Hall, had all these chances to talk to the police and never brought up self-defense. It's a subtle difference, but I think it is a difference with a meaning.
Understood. I mean, all I intend to say during the closing argument is that during the phone conversation that was initiated by Ms. Stuckey, you didn't hear once the defendant mentioned he was protecting himself. You didn't hear once the defendant was protecting his phone, and you didn't hear once the defendant was protecting his family.
Okay.
That's the evidence.
All right, and you're free to object to that. I won't view that as being disruptive. If that's the format in which it's presented, more or less, I will overrule the objection. But okay, great. Let's bring the jury in, please.
All right, observe. I'll do it further than accounted for.
Welcome back, ladies and gentlemen. This is now time for the state's part 2 or rebuttal closing. Mr. Abate will be presenting that on behalf of the state. When you are ready, sir.
We're gonna say it again. The defendant's man was questioned. Detectives very summed it up in one sentence. It sounds like your manhood was questioned. But what did you hear after she said that? What did you hear after she said that? Nothing. You heard nothing. You heard the defendant on the other line, it go dead. Soon as Detective Barry mentions it, brings it up, tells the defendant exactly why he acted the way he did that night, exactly why he murdered Corey Blunt, he hung up. The phone went dead, whatever it may be, but he wasn't on the other end of that line again. That was the facts and the evidence, ladies and gentlemen. His ego, not once, not twice, was questioned. And his answer to Corey was 8 shots through the door. 8 shots through the door. It was an ambush, ladies and gentlemen. Why do I say that? Because he waited till that door closed to unleash 8 bullets through the door. 8 bullets. It was a cowardly act. It was a cowardly act that ended the life of Corey Blunt, who was just trying to make sure that Miss Stuckey was okay. Was just trying to make sure that the person who was supposed to love her, be kind to her, did just that. The final acts of Corey's life was trying to protect someone, whether Miss Stuckey wants to say it or not, someone he saw as a mother. That's what the facts and the evidence are. I want to point out some of the key facts and the evidence, and I'm going to be brief, because I know you guys have been sitting here for a while. And I know, like Ms. Feely and Mr. Ralph pointed out, we've been taking notes. We've all seen you be very attentive over the last couple of days. And I know you're ready to get back in that deliberation room and to begin reviewing the evidence and your notes and the things that you wrote down and you remember in the last couple of days, so you can make a determination. And like Mr. Ralph said, no one says that your job is easy. You have the hardest job here, because you have to go through all the facts and all the evidence, and you, ladies and gentlemen, you determine what happened on April 30th of 2022. You determine what happened based on all the evidence that you heard, that you saw from that witness stand, and that was admitted during the trial of this case. It's a hard job. No one's minimizing that. But the state made your job easier by providing you all of the evidence and all of the testimony over the last couple of days, and they all point to the defendant unleashed 8 bullets at Corey, who was just behind the door, and he knew it. At Miss Scott, who was just behind the door, and he knew it. In an apartment building that he knew he had neighbors, unleashed 8 shots. By the grace of God, Miss Scott was able to sit before you and tell you everything that she heard, everything that she saw, and everything that she remembered. And you want to know why you didn't hear the recording from Miss Scott? Because Miss Scott was not inconsistent. Miss Scott was not minimizing what happened that night. You heard Miss Stuckey's recorded interview because she did just that. And the law here in the state of Georgia allows you, ladies and gentlemen, to hear that, because the law is intended so you hear the best evidence, so you hear all of the facts and circumstances, not to hide it from you because somebody wants to get up there and minimize what happened, minimize their role. It's completely understandable why she did it. Corey's family is sitting out in the audience. The person that she had spent the last 7 years, good, bad, ugly, whatever it may be, sitting right there, staring at her. Of course, it's a difficult situation. And of course, she says, I don't recall, or things that aren't what she said, close in time, on the night, on April 30th of 2022. And you heard her during that interview say, hold on, stop, literally pause, Detective Berry, and say, I want to be factual. I want to get it right. You heard her say that during the recorded interview. And that's important. That's important because she wanted to make sure Detective Berry knew everything. No matter what. Whether it looked good for her, good for him, good for her daughter, or good for Corey. And that's what you heard during that recorded interview. And that's why you heard it, ladies and gentlemen. And what you heard during the course of this trial, what you heard from Ms. Scott, Ms. Stuckey, and the defendant himself during that phone call, and all the other witnesses and from the evidence, is that Ms. Scott and Mr. Blount, Mr. Blount, no names, that around 9:30 on April 30th of 2022, left their East Point apartment. They left to drive to 537 Sunset Avenue to take Ms. Scott's daughter to see her grandmother, spend the night, and go to the aquarium the next day with Ms. Stuckey and her cousin. They arrived about 15, 20 minutes later. And what Ms. Scott told you is that when you saw Corey's vehicle had some damage in the front, that the engine was loud. So they turned it off. And when they turned it off, what she said she heard was loud arguing and loud yelling. And she immediately recognized those voices. Because she told you that wasn't the first time she had heard that. She told you once she heard that, her mom, Ms. Stuckey, came down. They began to have a conversation. They talked about what Ms. Scott, Corey, and Ms. heard from Ms. Stuckey and the defendant. And you heard from Ms. Stuckey as she sat there. You heard from Ms. Scott as she sat there. You heard from Ms. Stuckey's recorded interview that Ms. Stuckey said something along the lines, you don't think my granddaughter's gonna be safe? You heard her say that. And as a result of her saying that, Ms. Scott followed Ms. Stuckey up to their apartment to do just that, to determine if tonight was gonna be a night, whether her daughter was allowed to stay or not stay. And what did Ms. Scott tell you? That the minute they walked into that door, the minute they got into that apartment, the defendant came around in the back bedroom, pointed in her face, was aggressive to her by pointing in her face, and called her something along the lines of an MFer or you MFer this or you MFer did that, whatever it was. That's aggression. Those are acts that are unpredictable. And you never really heard why. Ms. Scott told you that as soon as they walked in, that's how he acted. She had no idea why. That was the evidence. And the evidence showed that at that point, Ms. Scott and Ms. Stuckey went back down to the car where Corey and Ms. Scott's daughter and Ms. Stuckey's granddaughter were waiting, and that the conversation continued. They talked about what just had happened in the apartment moments ago. They talked about what happened in the recent past, about Ms. Stuckey's tires being slit, about her windows being broken, and the arguments that they had. They talked about the fact that Ms. Stuckey was planning to leave the defendant. She was planning to leave the defendant. You didn't only hear that from Ms. Scott, but you heard that from Ms. Stuckey's interview. A consistency, another one. And that is very important because it goes to the state of mind, everything that Corey is hearing, everything that Corey is listening to as it relates to the volatility of the defendant. towards someone he's supposed to be loving and protect and to not harm. He's hearing all of that as he sits in the car and Ms. Scott and he try to get Ms. Stuckey to come with them. She declines. And then he offers to walk her up. He offers to walk someone that he saw as a mother-like figure up to the apartment where she lived. Up to the apartment that was hers, that she paid for, that her name and her name only was on the lease, up to her house. He wanted to walk her up to her house to make sure that she was protected and safe in her own home from that man. That's what happened that night. That's why Corey went up to apartment number 2. There's nothing nefarious about that. There's nothing wrong about wanting to protect the people that are close to you, that you love, that the people you love. You heard from Ms. Scott about the strong connection that her and Mr. Blunt had. How when they got reacquainted and immediately the connection was there and they moved in together. And she told you that her family is like his family. She told you about the relationship between him and Ms. Stuckey, the texting and things of that nature, that of course Ms. Stuckey wanted to minimize as she sat and testified in front of the defendant. In front of somebody who had slid her tires, broken her windows, yelled at her and demeaned her in front of her children, in front of her daughter. Who could blame her? Who could blame her? As you go through and sift through the evidence and your notes and all the testimony, it's important, like Mr. Rao said, to use your life experience, use your common sense, apply that to the facts and the evidence, apply that to why Ms. Stuckey, as she sat in front of each and every one of you, telling you about what I can imagine is one of the hardest and most difficult times in her life to remember, about a bad relationship that she was in, about an event that you heard from her interview was going to affect her relationship with her daughter, and about watching a 21-year-old kid bleed out on the steps, on the landing, right in front of her apartment. Think about that when you're thinking about why Ms. Stuckey's recorded interview, that the authenticity of was not questioned. I didn't hear an objection, did you? Did you? It's kind of like the silence after Detective Barry said to the defendant, sounds like your manhood was questioned. Perfect. That's because it was. But because it was, he acted out of anger. He shot cowardly 8 times through that door. That, ladies and gentlemen, is the facts and the evidence. What the evidence showed was uncontroverted between the video, between the statement from Scott, she sat before you, and the testimony of Ms. Stuckey, she also sat before you. That before he comes into the apartment, there's a disagreement, some sort of exchange between the defendant and Corey. And what's important from that recorded interview, and as was pointed out earlier by Mr. Rao, every time that Detective Barry asked Ms. Stuckey about the firearm that Corey had and what he did with it, she acted it out. She showed it to her. And when she did, she always pointed to his waist and pulled up right here. Never separated, never pointed, never did any of that. And you hear during that interview after the phone call with the defendant, where the defendant says that he pulled the gun, pointed. That's what Ms. Stuckey, when asked by Detective Barry described again, says, well, he never pointed it, but he may have separated it from his body some. And she said that on the stand. Never once did she say that Corey threatened or pointed a gun at the defendant. It's not illegal to own a firearm. We talked all about owning a firearm, carrying a firearm during voir dire or jury selection. We all ask you endless questions about that and about your gun ownership and if you own a gun, what type, why, things of that nature, prying into your personal lives, which we apologize for. But the point of that was to show you, based on your life experience, that there's something unusual about the fact that Corey was carrying a firearm. He was legally carrying a firearm. There's absolutely no evidence that Corey pointed that gun at the defendant, that Corey mentioned, said one threat to the defendant. I challenge you to go through your notes, to go through your memory. Not once did Ms. Stuckey, not once did Ms. Scott, not once did anyone say that the defendant or that the victim threatened the defendant in any way. Not once. Not once. And what the evidence showed is that Ms. Scott heard the commotion upstairs. She didn't heard arguing. She told you she heard a glass break. And that prompted her to go up the stairs. And what she told you, this is exactly what Ms. Stuckey told you as she sat before each and every one of you, that Corey was outside of the door. She pushed him out, whatever, helped him out. And that Ms. Scott came up the stairs. And she saw Ms. Scott. And Ms. Scott told you she not only saw Corey outside of the door, she saw her mother just inside the threshold or in the doorway, and she could see the defendant behind Ms. Stuckey, which is exactly what Ms. Stuckey said. And then everyone then said the next thing that happened is the door closed. And Ms. Scott told you that as the door was closing, she grabbed Corey's hand. They turned to head down the stairs. And you know they turned to go down the stairs because all of the gunshots on Corey's body, head, are on his right side, which is consistent with them turning to head down the stairs. And Ms. Scott told you the next thing that she heard, that she felt, that she realized was that her and Corey's hands were disconnected. She immediately heard a barrage of gunfire. And she headed towards her down the stairs to escape getting shot. And luckily, she did. She was only grazed. And you heard her say that afterwards, after the gunshots stopped, she immediately called out for Corey. She wondered why Corey wasn't behind her. She realized he was shot. She told you she went to her car to quickly get her cell phone, go back upstairs, and attempt to render aid, attempt to try to save Corey's life. And what she told you, and what you see on the videos, is that while she's doing that, the defendant's in and out of the apartment, walking around with his gun in his hand. She tells you she attempts to continue to call 911, but she can't get through. So she goes back down the stairs and attempts to look for help. And she finds someone. She finds a good Samaritan, somebody who's willing to help. And you know that's true because you hear the 911 call. And what Ms. Scott told you, and what is said on that 911 recording, is that you can hear her. He takes the phone and says that she's hysterical, she's upset, and he begins to talk with the 911 operator. That's what the facts and the evidence were. And on that 911 call, you can hear the male that, yes, did not sit before you, ladies and gentlemen, but he didn't have to hear his testimony. You heard it. It's on the 911 recording. It was captured at the time everything was going on. The defense counsel wants to make it seem as if the state's hiding something from you, because the Good Samaritan who didn't witness anything just was brought up to help render aid to Corey, and is all captured on the 911 recording. We're trying to hide something from you. And what the evidence showed, that the 911 call was received and dispatched at 10:12 p.m. And what the CAD report, states exhibit, I believe it's 124, 123, shows is that Officer Coffin at the time, now investigator, Coffin arrived 2 minutes and 21 seconds later. The defense counsel wants you to think, well, the 911 call cut off. Why? There's something nefarious or something the state's trying to hide because there isn't a follow-up call. There's not a follow-up call, ladies and gentlemen, because at the end of that call, you can hear sirens. You can hear police sirens. That's because they're there in 2 minutes and 21 seconds. The police arrive. They're there. There's no need to call 911 back. They're there. The people who dispatched them were on the other end of that call and hear that. It worked. You see, or on the, you hear from the sky, from Miss Stuckey, that the police and medical personnel attempt to do life-saving measures on Mr. Blunt, but they can't. The injuries are too severe, and he's pronounced deceased on the scene. Other officers and detectives from the Atlanta Police Department arrive, along with Detective Barry. She tells you she's the first detective or investigator with the Atlanta Homicide Unit to arrive, and she's the lead detective. And she tells you once she arrived, she surveys the scene, goes with crime scene tech Davis to look at the evidence in other areas of the apartment complex. And then she tells you she begins to talk to the witnesses, including neighbors, which you hear in Ms. Stuckey's interview, who all said that they heard arguing between Ms. Stuckey and the defendant often. And then they head back to the Atlanta Police Headquarters down the street from right where we are here today. And you saw, and I won't go through what you heard and what you saw during Ms. Stuckey's interview. Like everyone has pointed out, we all saw you taking notes. During that interview, Ms. Stuckey, without Detective Barry asking, calls the defendant. You heard that call, and you heard the things the defendant said during that call, and you heard the abrupt end to that call. You heard during that call the defendant get Detective Barry's information. In fact, you heard Detective Barry say, "I'll text you the information." Does it? And ask, "Did you get it?" And you hear the defendant say, "Yes." You heard that there was a 2 o'clock appointment for the next day, and you learned.
Objection. And I also have an objection to what's on the slide.
I can't see what's on the slide, so can you quickly narrate it? Do I need to jump down? Pardon me? Sure, you want to take a quick pause? Can you switch the slide real quickly? Can you make sure whatever slide is up there is not also an objection, Ms. Feely? Just so whatever's sitting up there. I don't know what's on the screen now. It's good? Okay. All right. Hold your thoughts, jurors. So ladies and gentlemen, just so you know, not the substance of what we talked about, because that was outside your presence, but just sort of what's going on here. There are a number of areas that we've talked about that the state needs to not go into for legal reasons. And Ms. Feely is in the unenviable position of trying to think where Mr. Abate might go next. She had a concern that he was about to talk about something that I had instructed him not to. He said, I wasn't going to because you said I shouldn't. But Ms. Feely has no way of knowing. And if that comes out, then it may be one of those motions I told you about. And we don't want motions now. We're very, very far into the trial. And so hopefully we can avoid something like that. But that's something that we need to talk about outside your presence. No one has done anything problematic. Ms. Feely was protecting her client's rights. And Mr. Abate was mounting a vigorous presentation of the state's case, which you may resume doing.
Well, it's much bigger, but where we left off was there was an appointment that was made for the next day for the defendant to come meet with Detective Berry at 2 p.m. And the evidence showed that the defendant no-showed. The next thing you heard through the facts, the evidence, and the testimony is that the defendant was arrested in Ohio on June 22nd with a significant change in his appearance. He had dreadlocks that were down to mid bicep, and he now had very short hair. And if you recall, and as Ms. Feely brought up, Detective Berry also got a haircut since April 30th, 2022. I want to be clear to each and every one of you, there's nothing wrong with getting a haircut. But Detective Berry didn't commit a murder on April 30th, 2022. So her haircut isn't significant. It's just a change. It's a change in how she wanted to wear her hair. The point of the evidence of the defendant's change in his hair is because he changed his hair after he shot 8 times through a door, killing Mr. Blunt, no showing for an appointment he had made with the detective. The next time you hear or see from the defendant is in Ohio, mid-June, or toward the end of June. And he no longer has dreadlocks. That I know from your common sense and your reason, take a long time to grow. It's not something that just happens overnight. It's years and years and years and years to grow. Hair that long. And he cut it. He cut it after he shot and killed 41. That was the point of that evidence. To show you the consciousness of guilt of this defendant. After he acted in a fit of rage, a fit of anger, because he was questioned. That's the point of the evidence. Now, you've heard a lot about self-defense, and you heard Mr. Ralph and Ms. Feely define it, tell you what it means under the law. I'm gonna tell you a little about why this is not self-defense. The 3 key things you have to remember is it's not self-defense because Corey was leaving. Corey's gun was in his waistband, not being presented, not being shown, not his hand on. What he had his hand on was his phone, like most 21-year-old kids. That's what he was doing. And the door was closed. That's how you know this is self-defense. That's how you know this is murder. I want to make it clear, the state isn't commenting on whether the defendant is a good or bad person. I don't know him. The state doesn't know the defendant. What I'm asking you to do is to sift and go through the facts and the evidence and determine what he did that night, what his actions were that night. You shouldn't care whether he's a good or bad person either. What you should care about is what he did and why he did it. And what he did was murder Corey. And he did it because instead of him protecting the Stuckey, it was Corey. He felt embarrassed. He felt judged, probably. And he reacted. And he reacted with a gun. And let me tell you, who didn't react with a gun? Who you've heard about who had one? Corey! Corey had a gun. He didn't react to anything the defendant did. You didn't hear about Corey shooting anyone. You heard again, Corey exercising restraint and the defendant not. That's what the evidence was. What's important about you all seeing this video again was that the door was closed and Corey had nothing but a phone in his hand. I'm not going to play it 5, 6 more times like defense counsel said I would. You've seen it enough. But the point is, he's at this point not a threat. I submit to you, ladies and gentlemen, he never was a threat in the sense that he was never committing any sort of violent felony towards the defendant. He never pointed a gun at the defendant. That's aggravated assault. Or he wasn't committing that. Or he let him know that he was armed after they had a heated exchange, is what I would submit to you, ladies and gentlemen, occurred that night. Just like the defendant, Corey could have chosen to use his firearm, but again, he didn't. And there's a reason why he didn't, because he went up there to protect Miss Stuckey. That's the long and short of it. That's it. That was the evidence. Nothing more, nothing less. And how do you know he was leaving? You heard it from Miss Stuckey. You heard it from Miss Scott. You actually heard it from the defendant during that call. You heard him say that Corey turned and it was heading towards the door. That's when he went and got his gun or and shot. The physical evidence shows you that he was leaving. 8 shots through the door. All of the shell casings are found inside the house. The video shows you that Corey and Miss Scott were leaving when the defendant shot through that door. And the science shows you that Corey was leaving. Dr. Karen Sullivan's testimony about the trajectory and where Corey was hit all corroborate and prove beyond a reasonable doubt that Corey was leaving that apartment, just like Miss Stuckey and just like Miss Scott and just like the defendant said. And when someone's leaving, there's no threat. There's no threat. How do we know there was no threat? You see it in the video. You don't see Corey's gun because it's secured in his waist, just like Ms. Scott said. You heard from Ms. Stuckey. She said she didn't see a gun when Corey was leaving. She said it while she sat on the stand. She said it during her interview. The physical evidence, not only from the video, but the fact that what was marked right next to Corey's body was his cell phone, which you see fall out of his hand on the video. The door was closed, ladies and gentlemen. The phone was right next to Corey's body. That's the evidence. And you heard it, all the same things we just talked about. The Stuckey, Scott, the physical evidence. Now, the defense wants you to think that the state's presenting you with smoke and mirrors so you can see reflections of things that aren't there, and all of those distractions that she described. She talked about Miss Scott giving the gun to Officer Coffey. You heard the testimony of the officer, and he told you that when he arrived, that was the first thing that Miss Scott did. If Miss Scott wanted to do something to tamper with the scene or mess up the investigation, there's a lot of things different that she could have done. If she didn't want the police to know that Corey at the time had his gun secured in his waistband, guess what she would have done? She would have taken that gun, would have put it in her car, and they would have known that Corey had a gun. There would have been no gun to find. You would have Miss Stuckey saying there was that Corey had a gun close to his side, but no firearm. She didn't do that. She immediately did what a reasonable person would do, is provide the officers with a firearm as soon as they arrive. Defense wants you to think that there's something the state's doing to hide because the ring camera video surveillance isn't up to her mark. Ring cameras, whether you're in the Bluff, Buckhead, Johns Creek, Sandy Springs, they're all the same. They're made by Ring. So I don't know what it has to do with anyone's socioeconomic status or where they live or whatever their nature. If she's got a complaint with the video, she should call Ring. Not the state. Not Mr. Cunningham. She should talk to a customer service representative with Ring and let them know that their technology and their surveillance cameras are not up to her standards. That's the solution to that problem. But the evidence was uncontroverted that Mr. Cunningham went through those videos and provided everything that he could to Detective Barry that related to anything that involved Corey, the defendant, and Scott and Miss Stuckey. Then you heard from Detective Barry that not only did he do that, but she went through, he gave her the device with his password and plugged it in, and then she went through all of the video surveillance for that time span, and that's all she found. But that's the state's fault, because a Ring camera was motion activated, and it only activated once Corey fell towards the door that it was meant to surveil. No fingerprints were done. That Miss Stuckey's fingerprints could be on the gun. The defendant himself said he shot. He said he shot. I'm not sure what fingerprints would have done to change that fact. That there was no arguing. That the neighbor didn't hear arguing. That Mr. Seals didn't hear the arguing between Ms. Stuckey and the defendant. But the problem is that they both admitted that they were arguing loudly, just like Ms. Scott testified. The attempt to shake Corey's hand. She wants to make that seem as if that the defendant got up in an attempt of trying to be friendly. But I would urge you, ladies and gentlemen, to remember the facts of the evidence. That how the defendant acted is a window to how he acted when Mr. Blunt came into that apartment. Came into that apartment that was leased and owned by Ms. Stuckey, that she welcomed him into, as if he wasn't welcome to enter an apartment that didn't belong to the defendant either. But the interaction between Ms. Scott, Ms. Stuckey, and the defendant that happened earlier is a window into how the defendant greeted Ms. Stuckey and Mr. Blunt. They want you to believe it was a handshake. She wants you to, I guess, consider the victim had a gun. I was confused by that because it's been no secret that Corey had a firearm. No one hid that from you. No one tried to minimize it, not talk about it. We admitted the actual gun into evidence. I'm not sure what she believes that's a distraction to or for, but you have the gun. That Corey threatened the defendant in any way. There's absolutely no evidence of that. Not a single witness of what occurred said that Corey had ever threatened anyone. The testimony has always been, and the evidence will be, that Corey went up there to make sure that Ms. Stuckey was safe. We talked about Ms. Stuckey's interview. The defense said that Corey was unknown, false, unpredictable. The one who was unpredictable was the defendant. An arm was a deadly weapon. So was the defendant. And he used it. He pulled that trigger 8 times. 2 of those bullets hit Corey. One through the right side of his head, and the second one into his right side of his chest. You heard Dr. Sullivan say, hit both of his lungs in his aorta and exited from his back. We talked about the 911 call being cut off for no reason, and want you to think that there's some big mystery about the 911. It's Good Samaritan who took over the call, not being here. Well, you heard what his testimony is. Will actually work.
This is your technology now, not the court's.
What is the address? They got a shot, he said there was a person shot? Somebody shot down. Okay, Sunset and Melvin? Melvin, yeah. Okay, stand on line, put it in, and do not hang up, thank you. Okay, all right, do this again. Go on out. I know. Couldn't hear that. Operator 933. It's Atlanta. Home about the intersection of Sunset Avenue and Melvin Street. Caller, you on the line? Hello? Yes, sir. Straight in at the 911. This is Sunset and Melvin. What's the phone you're calling from today? I don't know. It's a young lady gave me a phone. Claiming that weapon is shot down. Okay, give me 1 second. Don't hang up. Okay, I'm gonna get over radio the week. All right, thank you so much. Are you with the patient now? Yeah, all right. Okay. How old is the person? How old is he? 21. Okay. Is he awake? Yeah. Keep on. Is he awake? They're not. Don't. Sir? Hey, sir, is he awake? Okay, is he breathing? He's already breathing. Hold on, is he breathing? Is he breathing? I'm feeling breathing. Okay, give me 1 second, don't hang up, okay? I need to give you some instructions, okay? Give me 1 moment, I need this information, I'm needed for the paramedics, okay? 1 moment, see it on there. Request expire on a 27th of 1 call. And 27th, that's the 1 call, you say he's not breathing? Not fine, thank you. What's your operator? 7933, let's go. I'm operator 933. Thank you. All right, sir, listen to me very carefully. If the assailant is still nearby, they got to do something. Yes, sir, we already have someone on the way to help you, okay? But I need you to cooperate with me during this time. Get us some help, okay? Lord, I understand. Is the assailant still nearby? Is the what? Is the attacker still nearby? Okay, we already have help on the way, okay? All right, give me 1 moment. Is there any serious bleeding? Yes. Mr. Carter, so read, you can go ahead and start CPR. I know, oh my God. We have somebody on the way, we have police, fire, ATM that's on the way, okay, don't pick up. But it's 2 hours, I
Consistent. Consistent with the evidence, consistent with the testimony. She wants you to ignore the 8 holes in the door, the 8 shell casings that were found inside of the defendant's apartment, inside of the apartment the defendant was in. The defendant's gun hidden under the black couch. The lack thereof, shell casings on the landing or outside the door, indicating that exactly what Ms. Scott and Ms. Stuckey said, that Corey never used his gun. She wants you to ignore the video. The defense wants you to ignore the flight of the defendant. And she wants you to consider that, though, that his flight was because you heard that there was quite a scene after later on when police arrived. A scene that the defendant didn't stick around for. Because the 911 call came in at 10:12, 2 minutes and 21 seconds later. First responding officer arrives, followed by other members of the Atlanta Police Department, but the defendant's not there. 2 minutes and 21 seconds after the 911 call. There was no scene. The only scene was what he left behind. That was the scene. What he left behind was Corey laying dead on the cold pavement of that landing, shot twice, in the head and the chest. She wants you to ignore his significant change in appearance. She wants you to ignore that because Detective Barry also got a haircut the night after she shot and killed somebody. She wants you to ignore the trajectory that was shown and testified to by Dr. Karen Sullivan, the chief medical examiner for Fulton County. She wants you to ignore the report that the defense stipulated to, that all 8 of those shell casings, the only shell casings that were found that night inside of the apartment, matched to the defendant's gun. She wants you to ignore that. A gun which the serial number had been obliterated, and that, as the report indicates, the firearms analyst, Jay Jarvis, had to restore. She wants you to ignore all of that. She wants you to ignore why 21-year-old Corey Blunt went into that apartment that night. She wants you to ignore the fact that he had to go into that apartment to protect Ms. Stuckey. She wants you to ignore all of that. But I know that you wrote almost everything down. You saw how attentive you were. Remember what the defendant said. I'm not going to go through all of this again, but remember the theme of what the defendant said. That he had been checked, and that he had been checked by a kid. And he's a grown-ass man. That's the theme of what the defendant's statement through that phone call said. Nothing more and nothing less. And I want you to remember what the defendant didn't say during that call. You didn't hear him once say he was protecting himself. You didn't hear him once say that he was protecting his home, Ms. Stuckey's home. And you didn't hear him once say that he was protecting Ms. Stuckey or his family. The evidence actually showed he was doing the opposite. He put Ms. Scott and Ms. Stuckey in just as great of danger that he put Corey in, that ended his life. And again, by the grace of God, we don't have 3 dead people from his actions on April 30th, 2022. Remember that. Remember the 8 shots that he fired cowardly through that closed door, knowing that Corey and Ms. Scott were on the other side of it. And he did it without any care of human life or regard for Miss Scott or that little boy. Ladies and gentlemen, I know Mr. Rao talked to you a little bit about the burden of proof. The state has the burden of proof to show you beyond a reasonable doubt that the defendant is guilty of every count in the indictment, every element of each of the charges. And I know Mr. Rao told you a little bit about how he is able to understand reasonable doubt. I have my own story that I use when I think of reasonable doubt. I use my real life experiences, just like you guys should when you're deliberating. And the example I give is that I have a younger brother. He's 6 years younger than me. And when I went off to college, I went to UGA, and he was still living at home, obviously with my parents. And on holidays, I'd come home, Thanksgiving, Christmas, and because it's a dorm, you don't have room for all of your clothes, so I left a lot of clothes in my closet. And I would come home for Thanksgiving break, for Christmas break, whatever break there may be, or on the weekends, and I go in my closet, and I would go to put on a shirt, a jacket, something of that nature. And I would always smell something distinctive on certain items of clothing that I knew he loved. And I'd put it on, and I'd smell curved cologne that I can't stand, that I didn't wear. And I tell you this because I didn't see him wear the clothing. I didn't see a picture of it. I didn't see him put it on. None of that. But I know he wore it because he's the only one in that household who wore curved cologne, who loved certain items of clothing that I left behind. I know beyond a reasonable doubt that at some point while I was gone, that my brother Luke wore that. I know it, and I didn't see it. When he died a number of years ago, he was killed, and I would give anything to come home, put on a shirt, and smell that cologne. You wanna know who else would give anything? To have Corey sitting at the dinner table, to have Corey to celebrate Thanksgiving, celebrate Christmas, his family. His family. The defendant took that from him. Took that from them. He took that when he fired 8 shots into a closed room that he knew Corey and Scott. 8 shots. 8 shots. The cowardly act that ended the life of 21-year-old boy. His life was just getting started. The defendant took that from them. And you, ladies and gentlemen, you get to tell him that there are consequences for his actions. That every action has an equal reaction. Like Ms. Camp told you. And you can do that with your verdict. And as you sit back in the deliberation room, you go through the facts and the evidence, you go through your notes, you talk about what you heard, what you saw, what you remember. I am confident that you will reach the only verdict that speaks the truth. That your recollection of the facts and the evidence is that this defendant is guilty of each and every count of that indictment. Murder, felony murder, aggravated assault, and possession of a firearm and ammunition. That the state, like its burden, it proved beyond a reasonable doubt. Smell that cologne.
Thank you, Mr. Abate. Ladies and gentlemen, we're about 15 minutes shy of the day you committed to. We've used it fully. I know you had some breaks, but they really are natural breaks in the flow, the ebb and flow of a trial. I'm going to send you home now. Tomorrow, I need to charge you. That'll take about 30 minutes, 25, 30 minutes to give you the law. I have to read it to you. That's required by the law. But I'll also give it to you. You'll have a copy of it. It's not the most dynamic part of the trial, but it's a fundamental part of the trial. I'd love for us to do that at 9 tomorrow, but tomorrow is pretty much your day. Once you begin your deliberations, you go till you want a break. When you want lunch, you break for lunch. When you need a break, you break. So I've sort of dictated, or the flow of the trial has dictated when we start and stop. The last little bit is that, and then you control it. Is there anyone for whom a 9 a.m. start would be a problem? Great. Then just like yesterday, not today, yesterday, try to be here by 9. We can't start until all 14 of you are here. And then I'll share with you the law that you must apply to the facts as you find them to be. We're close to when you can talk with each other about the case. You still need to not talk about the case with people who are saying, come on, when can I hear what you've been doing? The answer is soon, but not yet. So please, no outside research. Don't talk about this case and your experience with anyone other than to say, we're having a great time, and I'll tell you more later. A logistical or process question, because a hand went up. Oh, we're starting at 9. I wasn't going to suggest anything later unless you all say, hey, we voted, you made us stay late today. So we're sleeping in, and we want to come at 10. So I'll assume you'll all be here at 9, and we'll do our usual start calling people if it's 8:55 and you're not here. Take your notepads, leave them in the jury room. If you're running low on any supplies, let Deputy Gordon know. We'll send them to Publix and he can stock up. Okay? Thank you, everyone.
All rise, reserve.
All right. I want to get a couple things on the record. You all can be seated. You can go if you want to go back in the gallery. First, when we're done today, I'm going to give to Ms. Rivers all 58 cards with juror questions. That will be Court Exhibit 1. This includes cards that have questions that were not asked. There are some cards that's all that was on there were questions that were not asked. This is the entire universe of the questions. That'll be made part of the record. I have a verdict form, and I'd like to get that blessed tonight. Chosen, if you don't mind coming on up here to, well, we'll give you exercise. Come on up here. And if the defense could look at it, and then the state. And then we need to work through defense of habitation, what we're going to include from that. And I can get you all a final charge. I'll email that to you. You don't need to stick around for that, but I think we've finalized it. Ms. Feely, did you have a concern about the verdict form? If we need to talk about it in the morning, I can actually just leave that with you. You want to just talk about it in the morning? Okay. Mr. Abate, did you have an issue with the verdict form? Oh, if you haven't looked at it, how about we'll confer in the morning about the verdict. Okay, all right. But I'll get your final word on it in the morning. Let's talk about the jury charge, which I will once again share. All right, so on the screen is justification. It's going to be a single charge, defense of self or habitation, because it has the same lead in that sometimes use of force is legally justified. I'll get rid of threat. And so is not a crime. And then the first part you see on the bottom of page 9 and top of page 10, there's no change there. That this is, well, bottom of page 9, that's self-defense. But then, hold on one second. We get into habitation, and I'll clean it up a little bit, but you'll see the first one involves an unlawful entry. And we don't have an unlawful entry here. It's an unlawful entry in a violent and tumultuous manner. That's, keep in mind, defensive habitation is used when it's actually the household you're concerned about, not necessarily yourself. And we have both, but this case doesn't involve a violent and tumultuous unlawful entry. The only evidence is that Ms. Stuckey brought Mr. Blunt into the house. I don't think any of the unlawful entries, which is the justification, someone is breaking into my house, as opposed to, hey, my girlfriend just brought this guy in. I don't like the fact that she brought a guy in, but that's not defensive habitation. I don't think it's the first one. The second one involves unlawful and forcible entry into the residence, a la a burglary. Again, not this case, which leaves only one more, which is that the defendant reasonably believes that this other person is making entry to commit a felony. And that can't really be this case either, because it wasn't until, if we accept the defense version, it was called sort of the close to mainstream version, it wasn't until Mr. Blunt was up and Mr. Hall tried to shake his hand, and Mr. Blunt wouldn't have any of that, and he either showed his gun or pulled out his gun. He's well into the residence, and there's no reason prior to that for anyone to believe that a felony is occurring. He's not breaking the door down. He's not wearing a mask or anything like that. And so I'm wondering why defensive habitation applies at all, since those are the three scenarios. So that's what I'm wrestling with.
We believe that there is enough evidence to get this charge because.
Which one?
Subsection
1?
Yes.
The one about the violent and tumultuous unlawful entry?
Yes,
Okay. What's that evidence?
that he busted into my client's house again.
What's the busted in part?
I think there was conflict in the testimony. I don't think that the testimony was she opened the door for him and, hey, come on in. He was escorting her up, presumably because there was a danger that he was protecting her from.
Yeah.
And doing so with a firearm. So that's our request.
So you think it would be the first one, that it's the unlawful entry, okay. State spokesperson?
I would submit to the court that there's absolutely no evidence of any of the scenarios that you just went through that would apply to this case. And I would agree with the court that this is not an instance where defensive habitation is an appropriate charge to give the jury based on all of the facts and the evidence and arguments of not only the state but the defense.
It's clearly a self-defense case, self-defense. And when you asked for defensive habitation, I sort of reflexively said yes, because justification. But I hadn't looked at, your email simply gave the pattern number. And it wasn't until I asked Ms. Niles to send me the pattern charge that I began to see a square peg and a round hole, or at least an oval peg and a circular hole. I don't think you're way off the reservation. And my point is not, how do we know this was Mr. Hall's residence? I think there's ample evidence that the jury could conclude this is his castle. I'm not seeing the conflict in the evidence or the existence of any evidence that there was a violent and tumultuous entry. Not that there wasn't tumult eventually, but that's the breaking the door down, kicking the door in kind of thing, breaking a window. I'm not aware of any evidence to that effect. And there are only two sources. It would be Ms. Stuckey, or I guess what Ms. Scott could relay, like, yeah, I heard someone kick the door in, and I don't recall that. Number two, unlawful forcible entry into the residence. Again, it's not forcible. And then we get to number three, and that's this intent to commit a felony. And I don't think there's evidence that Mr. Hall had any sense at all that something was awry until Mr. Blunt was up in his business. And then he's concerned for his safety and defending himself, not so much the habitation. So that's what I'm struggling with. And if you want to put the final argument on this in the morning, I'm not trying to make folks at 5:56 struggle with argumentation, but I didn't want to wait till the morning to bring this to your attention, because we ought to start as close to 9 as we can.
Our request is still up because Ms. Scott testified about hearing glass breaking, and that's what caused her to run up. So, and we don't have the video of what was going on right before the shooting. So we are just requesting subsection 1.
Okay. All right. You're standing on your argument, Mr. Abate.
Yes, and then I even stand on the fact that that's the reason why the defense counsel didn't argue that in her closing argument, because it doesn't apply.
Okay. I also understand why she would like to cast the net as broadly as possible, and I respect that focus as well. But it doesn't mean everything comes in. I'm glad you're not also asking for alibi. Okay. Think about the verdict form.
So my request would be for it to be the first option, not guilty, the second option, voluntary, and the last option.
Okay, if we just flip those around, otherwise the skip 2 and 3, I've not done the skip 2 and 3 before. I think that's legally correct. If the jury finds Mr. Hall guilty of voluntary, then they're starting to get into repugnant verdicts. If they also, because for whatever reason, the state didn't charge felony murder predicated on possession of a firearm during commission of a felony. Maybe they can only be on by a convicted felon. But the only felony murder is based on the aggravated assault, and the aggravated assault goes away if there's a voluntary, which means then the felony murder goes away. The case law is pretty clear on that. And so I think counts 2 and 3 should be skipped. It's not a legal term if it's a voluntary.
No objection to that.
Okay.
We just want the not guilty.
Then voluntary, then murder. Just so we avoid, Edge doesn't apply quite like it used to, and that's way before your time, Mr. Bate, but do you have any concern if I flip those two around on the verdict form? Okay, I'll do that. We're avoiding one appellate issue if there's an appeal in this case.
You said something nice to me. You just made me imply that I'm young. I'm the same age as this feeling.
Well, that also, there was a lot of chatter on my internal texting when she said, I'm old, I was born in 82. And my staff's like, that's offensive. Not in a bad way, but just old is relative. Granny Feely, you're good with the verdict form if I make that change.
Yes, and we would just, for consistency, want the other counts to be not guilty than guilty.
Okay, I'll have them be similar. They just aren't going to have voluntary in there. And then we'll have one final quick conversation about defensive habitation. That would be the only change to the jury charge other than how it is now. I'll still send you something tonight, so you've got the rest of it, so you can give it one more read through. I'll charge the jury, and then they will deliberate. Anything else from the state? Okay, you guys you don't need to remove this from the courtroom, but at least before tomorrow morning start, we just need to have it out of the way. Anything from the defense?
Yeah.
All right, I noticed Mr. Hall sort of been shedding layers. Does he have something for tomorrow, or is he gonna be wearing like a t-shirt tomorrow?
I'm good.
Okay, as long as you got clothes, I wanna make sure you're presenting the way you wanna present. We're done. Thank you, everyone. Thank you, Ms. Rivers.
This applies in my case.